Leslie. Looks like we've just got a little less than a minute before we're back. Welcome back, everyone. Thank you so much for joining our keynote presentation. We are honored to have Risa Kaufman, Director of the United States Human Rights at the Center for Reproductive Rights, and Leah Rutman, the Healthcare and Liberty Counsel at the American Civil Liberties Union of Washington, with us today. Risa leads the Center of Reproductive Rights efforts to integrate international human rights norms and strategies to advance the full spectrum of reproductive rights in the United States, including access to abortion, as well as safe and respectful maternal health care. Prior to her work at the center, she was the executive director of Columbia Law School's Human Rights Institute. She's the co-author of the law school text, Human Rights Advocacy in the United States, and an adjunct law professor at NYU School of Law, where she teaches a seminar in US human rights advocacy. Risa holds a JD from NYU School of Law, where she was a Root Tilden Snow Scholar and clerked for Judge Ira Dement in the US District Court in Montgomery, Alabama. Leah's work at the ACLU focuses on reproductive health care, gender-affirming care, and health equity. She successfully drafted and advocated for numerous pieces of legislation in Washington state that protects and expands access to reproductive health care. Leah received her BA from McGill University and her JD from Columbia University School of Law. Welcome both Risa and Leah, and we will get started with Risa's presentation.
Great, thank you. It's really wonderful to be here. So thank you so much to the organizers for this opportunity. I'm really just thrilled to be in this virtual space and to learn from the participants, from my co-panelist Leah, and from the other presenters. So next slide, please. So in my time this afternoon, I'm going to be discussing the US Supreme Court's decision last June in Dobbs versus Jackson Women's Health Organization and the resulting national landscape. I'll put the decision and the situation in the United States into a global context, and then I'll start our discussion about the way forward. Next slide, please. So on June 24th, 2022, the US Supreme Court issued a decision in Dobbs versus Jackson Women's Health Organization, overturning Roe versus Wade and Planned Parenthood versus Casey, and dismantling 50 years of precedent protecting the constitutional right to abortion in the United States. At issue in Dobbs was the constitutionality of a Mississippi law banning abortion after 15 weeks of pregnancy. The challenge was brought by what was at the time the sole remaining abortion clinic in the state of Mississippi. In its decision in the case, the justices voted 6-3 to uphold Mississippi's 15-week ban and 5-4 to fully overrule Roe versus Wade and Planned Parenthood versus Casey. And while we know that Roe was never enough to secure robust protection for equal access to abortion everywhere and for everyone, it was a critically important floor of federal protection. The decision in Dobbs eliminates that protection. It announces that moving forward, all abortion laws and regulations will be assessed under the most lenient level of judicial scrutiny, rational basis. Under that standard, abortion restrictions are presumed valid and will be upheld so long as they're rationally related to a legitimate state interest. The majority writes that legitimate state interests include both previously recognized interests like fetal life and maternal health, as well as interests that have not been previously recognized and that have no grounding in facts or in science, such as mitigation of so-called fetal pain. This is a cataclysmic change in law, and it's a devastating loss. Never before has the court taken away a fundamental liberty right that generations have come to rely on and that has become so integral to the fabric of our society. The majority opinion was written by Justice Alito and joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett. It's almost identical to a draft opinion that had been leaked in May. The final opinion sets forth what is really a profoundly regressive view of what it means to be free and equal under the Constitution. The court states that unless a right is specifically enumerated in the Constitution It is only a protected liberty right under the 14th Amendment's Due Process Clause if it is, quote, deeply rooted in the nation's history and tradition. And then the court adopts a really extraordinarily narrow history and tradition analysis that asks only whether the right was protected by a majority of states at the time that the 14th Amendment was ratified in 1868. So as many scholars have noted, this analysis, of course, ignores the fact that the ratifiers of the 14th Amendment were white men who didn't view or allow women or people of color to be full and equal citizens with a voice in the political process. It also ignores the conditions of slavery that Black women endured, including sexual violence and forced birthing, which the anti-slavery 13th and 14th Amendments were also meant to address. The opinion sets forth a constitutional vision that essentially forecloses the possibility of progress or expansion of civil rights to those to whom they were previously denied. In the dissent's words, quote, when the majority asks that we must read our foundational charter as viewed at the time of ratification, except that we may also check it against the Dark Ages, consigns women to second-class citizenship. Now, the majority claims that its decision can be limited to abortion, but as the dissent makes clear, its reasoning is equally applicable to other liberty rights related to bodily integrity and autonomy. And quite revealingly, the majority opinion omits any mention of the impact of its ruling on the millions of people whose rights have been eviscerated. Justice Roberts wrote separately to concur in judgment only. He would uphold Mississippi's 15-week ban and discard Roe and Casey's viability line, but not reach the question of whether the Constitution protects the right to abortion. Justice Kavanaugh and Thomas each wrote separate concurring opinions. Justice Thomas makes clear that other important liberty rights are undermined by the court's decision. So whereas the majority claims that its ruling is limited to abortion, Justice Thomas acknowledges that when presented with a proper vehicle, he would likely go further to revoke liberty rights protected by the 14th Amendment's Due Process Clause. Justice Kavanaugh insists in his concurring opinion that the court is taking a neutral position by returning the issue of abortion to state legislatures. And here I'll just note the dissent's rejoinder. Quote, when the court decimates a right women have held for 50 years, the court is not being scrupulously neutral. It is instead taking sides against women who wish to exercise the right and for states like Mississippi that want to bar them from doing so. So there is a powerful dissent written by Justices Breyer, Kagan, and Sotomayor. It names the profound retrogression and harm inflicted by the court's decision, and it recognizes that this harm will not fall evenly and will instead be disproportionately felt by the most vulnerable. The dissent makes clear that liberty rights are interconnected and that abortion rights can't be so neatly excised from the scaffolding of substantive due process jurisprudence. And it calls the court out for breaching the rule of law and undermining its own legitimacy by reversing settled precedent based on nothing more than a change in composition. Next slide, please. So while the decision in Dobbs itself doesn't outlaw abortion in the United States, by taking away the federal constitutional right to abortion, it allows individual states to severely restrict or ban abortion if they choose to do so. And as we anticipated, the result has been legal chaos, and abortion access has been decimated across the country. In the immediate aftermath of the decision, states immediately moved to enforce trigger bans and pre-Roe bans, and they have filed motions to lift injunctions. The Center for Reproductive Rights is tracking and analyzing in real time the ever-changing landscape post-Roe with our interactive online map after Roe fell. And you see a snapshot here of the map from September 29th. Since the Dobbs decision on June 24th, 18 states have sought to enforce complete abortion bans, and 12 of those are currently in effect. So this means that right now, abortion is unlawful from the moment of conception, with very few exceptions in 12 states. In several other states, it's banned from points early in pregnancy. And additional states have either tried to enforce bans that have been blocked, or the status of the law is unclear. Another 14 or so states are also very hostile, having adopted layers upon layers of laws that are meant to make abortion access extremely difficult and to shut down clinics by making them have to comply with onerous requirements that have nothing to do with guaranteeing the quality of care. So this map also shows some good news. States where there have been successful legal advocacy or organizing work to remove legal barriers and add legal protections and expand access, like here in Washington. So as I said, the map you see here is a snapshot from September 29th, and the landscape has already changed. So for example, Leah is going to be discussing recent changes in Arizona that are not reflected on this map. The numbers go up and down, colors shift to weekly, if not daily, due to court proceedings. But the point here is that post-Roe, the landscape of abortion rights is constantly shifting. There's been legal chaos since the court's ruling, and people basically have no security in their rights. And in states where abortion remains legal, clinics are scrambling to accommodate an influx of out-of-state patients, resulting in increasing wait times, costs, and risks to patients. And some clinics have altogether stopped providing care due to perceived legal risk or the threat of retroactive liability. Leah will be sharing a deeper analysis of what this looks like in particular states, including in Washington and surrounding states. Next slide, please. So the efforts of progressive states to mitigate the impact of Dobbs notwithstanding, the impacts of the ruling are devastating. We know that abortion bans and restrictions disproportionately impact those who already face barriers to healthcare. Black, Indigenous, and other people of color, people living on low incomes and in poverty, people who are disabled, undocumented people, people living in rural areas, and young people. As states enforce abortion bans and clinics close, pregnant people are being forced to travel long distances to get care, sometimes across multiple state lines, which can exacerbate the hardships that many are already experiencing. And those without the means to travel will be forced to carry their pregnancies to term against their will or self-manage their abortions in cases where they might prefer to receive care from a provider, and making them vulnerable to criminal investigation and prosecution. Abortion bans and restrictions severely impact people's ability to access the full range of reproductive health care, regardless of their desired pregnancy outcome. So this includes abortion care, as well as care for miscarriage management and care needed for pregnancy complications. And although it's medically necessary for people to end their pregnancies at home with abortion pills, it's not without legal risk. So the loss of a constitutional protection for abortion dramatically increases the risk of criminal prosecutions among communities that are already disproportionately targeted. The Biden administration has taken some steps to try to mitigate the damage. So the administration has issued a series of executive orders and taken some agency action. For example, inviting states to apply for Medicaid waivers to expand abortion access for pregnant people traveling out of state by covering travel costs. The Department of Health and Human Services issued guidance clarifying that EMTALA, or the Emergency Medical Treatment and Active Labor Act, covers patients seeking reproductive healthcare services, and that this federal law preempts a directly conflicting state law that prohibits such treatment. And Leah will be discussing the use of EMTALA in greater detail. In September, the Department of Veterans Affairs issued an interim final rule lifting the ban on abortion counseling and permitting abortions at its health facilities when a pregnant veteran's life or health is at risk, or if the pregnancy was a result of rape or incest. Congress has now twice passed the Women's Health Protection Act, which is a federal law that would protect abortion access, but the Senate has failed to pass it when it came up for a vote this summer. There are a number of other bills that have been introduced which protect or purport to protect access to abortion. And as noted, a number of progressive states like Washington have expanded or protected access in response to Dobbs and hostile states' moves to ban abortion. But such moves can't fully prevent or remedy the devastating impact of the decision on people's lives, health, and well-being. And the court's decision overturning Roe threatens US constitutional liberty rights beyond abortion, including the right to contraception, to sexual intimacy, and the right to marry a person of the same sex or a different race. So before we move to a discussion about the implications of the Dobbs ruling here in Washington and neighboring states, I wanted to put the situation in the United States in a global context. Next slide, please. So it's important to recognize that and make very clear that what's happening in the United States is both counter to the global trend of liberalization of abortion and also a violation of human rights. The loss of constitutional protections for abortion makes the United States an outlier in a world where countries are increasingly liberalizing abortion rights. You see here that in the past 25 years, close to 60 countries have liberalized their laws and policies on abortion. Liberalization of abortion laws in Latin America and in Europe can be particularly instructive. So in Latin America, the feminist Green Wave movement has been successful in advocating for the liberalization of abortion in Colombia, Mexico, and Argentina. In 2022, the Colombia Constitutional Court issued a ruling decriminalizing abortion up to 24 weeks of gestation, and thereafter on specific grounds, including when the person's life or health is at risk, when the fetus isn't viable, and in cases of rape or incest. Previously in Colombia, abortion was permitted only on specific grounds. In 2021, the Mexican Supreme Court issued a ruling recognizing that denying women the right to safe and legal abortion is contrary to the right to reproductive autonomy, which the court found is protected under the Constitution. And in 2020, Argentina enacted a law permitting abortion during the first 14 weeks of pregnancy, where previously abortion had been very limited. In Europe, there's an overwhelmingly positive trend to liberalize abortion laws, which is evident from significant reforms to remove abortion bans, reform restrictive laws, and remove barriers. Over the past 5 years, many European countries have adopted important legal reforms that have ensured stronger protections for women's decision-making and access to abortion care. Laws that banned abortion have been removed, and highly restrictive laws have been liberalized in countries including Cyprus, Iceland, Ireland, Gibraltar, Northern Ireland, and San Marino. Even in those European countries where laws have long allowed for abortion, legal reforms to ease access to abortion care and remove remaining barriers are also being passed. So most recently, a number of major European jurisdictions enacted important changes to remove barriers to abortion access. Germany removed restrictions on abortion information provision, while both the Netherlands and France removed mandatory waiting periods. And following the Dobbs decision, lawmakers in at least 5 European countries, Belgium, Denmark, Finland, France, and Sweden, are now discussing concrete national reforms to strengthen protection and recognition for abortion rights in Europe in response to the Dobbs decision. In contrast, the United States is now one of only 4 countries where national legal protections for abortion have been removed. The other 3 countries that have removed legal grounds for abortion since 1994 are El Salvador, Nicaragua, and Poland. So you can actually track or see these trends and individual countries' abortion laws on the Center for Reproductive Rights World Abortion Map. Many of the bans that are being considered and enacted in the United States look a lot like those that are in place in some of the most restrictive regimes in the world. And in those countries, we know that restrictive abortion laws have not reduced abortion rates, but instead they've led to the harassment, the arrest, and the imprisonment of women and healthcare providers who are accused of violating restrictive abortion laws and have required people seeking care to resort to unsafe abortions. Next slide, please. So the profound retrogression of abortion rights in the United States violates human rights. Over the past 25 years, the international community has clarified that abortion is a fundamental human right that's critical to ensuring health, justice, and equality. Jurisprudence from international human rights bodies establishes that access to abortion is necessary to protect the rights to life, health, non-discrimination, information, privacy, and freedom from ill treatment, harmful practices, and gender-based violence. Abortion bans and restrictions violate core protections of human rights treaties that have been ratified by the United States, including the International Covenant on Civil and Political Rights, or the ICCPR, the Convention on the Elimination of Racial Discrimination, or the CERD, and the Convention Against Torture, the CAT. In March of this year, the World Health Organization, which is the leading global public health expert body, published an updated abortion care guideline, which recognizes abortion as an essential health service that's necessary to the realization of human rights. And US regression on abortion rights and the decision in Dobbs have been widely condemned as a violation of human rights. So responding to the Dobbs decision immediately after the Supreme Court issued the decision, the former UN High Commissioner for Human Rights, Michelle Bachelet, who was at the time the UN High Commissioner, reiterated human rights protections for abortion and the impact that the Dobbs decision will have on the fundamental rights of millions in the United States, particularly people with low incomes and people belonging to racial and ethnic minorities. UN independent human rights experts, including the UN Working Group on Discrimination Against Women and Girls, the UN Special Rapporteur on Health, and the UN Special Rapporteur on Violence Against Women, similarly denounced the decision in Dobbs. Next slide, please. So at the conclusion of a human rights review of the United States that took place this summer, the UN Committee on the Elimination of Race Discrimination, or the CERD Committee, noted deep concern with the Dobbs decision and recommended that the United States address the disparate impact that the decision and the loss of a right to abortion will have on racial and ethnic minorities, Indigenous women, and those with low income. So this picture is a picture of a delegation of US reproductive rights, health, and justice advocates who traveled to Geneva in August to present their concerns to the CERD Committee about maternal health inequities and the impact of abortion restrictions in US communities of color as part of the United States periodic review by the CERD Committee. The delegation included Black and Indigenous midwives, doulas, community organizers, reproductive health policy experts and educators, and leaders in abortion and maternal health care who have been directly impacted by US laws, policies, and practices that violate reproductive rights. The CERD's report on the US review, which it issued shortly after the review took place in August, concluded that systemic racism, along with intersecting factors such as gender, race, ethnicity, and migration status, have a profound impact on the ability of women and girls to access the full range of sexual and reproductive health services in the US without discrimination. And the committee recommended that the US take all necessary measures to address the disparate impact of the Dobbs decision, provide safe, legal, and effective access to abortion, mitigate the risks faced by women seeking an abortion and by health providers assisting them, and ensure that they're not subjected to criminal penalties. So the global community is watching and seeking to hold the US accountable for rights violations resulting from Dobbs. And as we look towards the future, we really can draw from human rights and from the advocacy of tremendous advocates around the world as a basis for rebuilding a more robust right to reproductive autonomy. So I'll end there, and with that, I will pass it to Leah. Thank you.
Hi, all. I will get started in a second. I think my slide's about to be put up, but I am so grateful to be here with all of you today and with my co-presenter, Risa. Especially grateful because I have been doing a lot of presentations on the Dobbs decision and what that means in the US, and none of them have addressed the international context. And so I'm just so grateful to Risa and for Nola to thinking about incorporating that into this discussion, and so that as we now look at the US and take a closer look of what's going on in the ground, we can have that lens. So I will be talking about the implications of the Dobbs decision and charting a path forward. Next slide, please. Specifically, we'll talk a bit about state examples of abortion bans, the consequences, the on-the-ground consequences for providers, pregnant persons, helpers. And then we'll do a case study of Washington State specifically, what's going on here and what steps can we take? And also touching very briefly on some of the federal actions we see in Congress. Next slide, please. So this is a map that you have already seen during Risa's presentation. And we wanted to come back here after you heard the international context to do a bit of a deeper dive. As Risa mentioned, this is an ever-changing landscape. And that ever-changing landscape has significant repercussions for lawyers, obviously, because it makes it difficult to analyze and know what to advise clients, but especially for patients and providers, because there is this new world where whether you can access your healthcare may be changing day by day. And keeping abreast of that and knowing what your rights are and what you're allowed and not allowed to do is really difficult, especially for people who do not spend their lives analyzing laws. As I had mentioned before, I do a significant number of these presentations. And one of the really telling things to me is I don't think I've ever been able to use this slide in any presentation I've done without changing it, because there are changes happening constantly. And so as Risa mentioned, I was going to talk a little today about Arizona, because as you will see here, Arizona looks maroon, so abortion being illegal. However, if you were to look at the Center for Reproductive Rights map today, you would find it is red, which is hostile. And let's dig a little into why that is. So in Arizona, you have a law from the 19th century that bans all abortion. And that law had been stopped by an injunction for almost 50 years. Now, a court, I believe on September 23rd, lifted that injunction. So that was in place. But at the same time, the Arizona legislature had passed a new bill that banned abortion at 15 weeks that I believe went into effect on September 24th. So now you have on one hand, this abortion ban that is no exceptions for rape or incest, an extreme abortion ban, and a new law that bans abortion at 15 weeks, and both are in effect. And so suddenly you had this map turning to illegal, but you also had an immense amount of confusion and fear when it came to patients, providers, and lawyers, because no one knew what to uphold at that point, and all abortions were stopping. Then soon thereafter, this was appealed, and the judge in that case put a temporary hold, I believe it granted an emergency stay, to say that the 19th century total ban was on hold for now. And so the 15-week ban was in effect, which is now why you're going to see Arizona appear red, hostile, because abortions are technically legal up to 15 weeks. But providers, patients, lawyers aren't sure what's going to happen in the future because that's just temporary and has to go up the court system. So I wanted to highlight that as this is Arizona's one example of this happening in many, many different states right now. And it really adds to the inequities that Risa was talking about and the disproportionate impact, because it requires significant information, education, ability to keep track of the news, so many different factors to be able to access abortion care safely and legally right now. I also want to highlight just briefly, when we're talking about abortion bans, what this looks like, right? So I'm going to use Texas as an example here, mainly because it's a good law. Texas had a trigger law that went into effect, I believe, on August 25th. Trigger laws are abortion bans that become effective if the Supreme Court overturns Roe versus Wade. This law created harsh penalties for persons who perform, induce, or attempts abortion. There is an exception for the life or health of the pregnant person to a degree, and there are penalties of at least $100,000 per violation and up to life imprisonment. The state of Texas also maintains that certain laws that were in effect prior to Roe still remain in effect. On top of all this, Texas passed, as I'm sure many of you heard about, even before Roe was overturned, a civil law called SB 8, and that prohibits abortion after about 6 weeks of pregnancy before many people know they are pregnant. And this extreme ban is essentially a bounty law. It incentivized citizens to bring lawsuits against fellow Texans. So anyone can sue someone else in Texas for breaking this law. Basically, you can sue an abortion provider and anyone who assists a pregnant person with accessing an abortion. So the Uber driver who drives that person to the abortion, the friend who lends money to the person who is seeking an abortion, all of this. And that citizen, if they are successful in their lawsuit, can receive at least $10,000 in damages. So it's really incentivizing people to sue each other. Next slide, please. And so we can talk about the laws and what the laws say, but I think what's really incredibly important here is the potential consequences of abortion bans. And these consequences differ for providers, helpers, and pregnant persons, those seeking abortion services. And I wanted to start here with providers. So obviously, one of the clearest form of consequences for providers is criminal and civil. Many of these laws are aimed at providers, right? Providers may go to jail. They may lose their licenses. They may have to pay significant funds for violating these laws and providing abortions to patients. And I want to highlight a couple of things here because you may think, okay, the way to avoid that consequence is not providing abortions. And there's tons of harm around that, but that could be, the solution in some of these situations for some of these providers. But there's gray areas that people don't really realize. One example I would give is if an abortion provider in Washington state provides an abortion to someone in Texas, it is legal in Washington state to provide that abortion. But what if this is through medication abortion, which often requires 2 different medications and a period of time before you take them, 48 hours. So that patient takes one of those pills in Washington state and then goes back and takes the other pill in Texas. Is Texas going to try to hold a Washington state provider responsible, claiming that that is an abortion provided in Texas? And while there's good reasons, good arguments to be made on the legal side that that wouldn't be feasible, that doesn't mean the claims won't be made. So it gets complicated. I also want to talk about, when we're talking about provider risk, emergency care. When talking about emergency care, it's hard not to talk about EMTALA, which is a federal law that I believe passed in 1986. It is the Emergency Medical Treatment and Labor Act. I think I got that acronym right. And among other important things, one of the things EMTALA requires is that if you show up in an emergency room and you are in need of emergency care, the hospital has to, at the very least, stabilize and transfer you. So if you are bleeding out in the hospital room, they have to do something for you. Now, when these abortion bans started to be passed, the Biden administration wanted to be clear that in situations that fall under EMTALA, so these emergency situations, it is still necessary to provide that care, even if the care necessary is an abortion, because in many instances of miscarriages, ectopic pregnancies, that might be the care that's required. So the Biden administration issued guidance and sent letters to providers, essentially saying to providers that if someone enters the emergency room and based on the provider's medical judgment, they need care and that care is abortion care, that care under EMTALA still needs to be provided, even if it runs contrary to state law. And as we know, federal law trumps state law due to the supremacy clause in the Constitution. Now, when the Biden administration came out with this guidance, the Attorney General in Texas sued the Biden administration almost immediately. And at the district court level, the court in Texas found in favor of the Attorney General for various reasons, but one being that the court determined that the guidance provided by the Biden administration went beyond the scope of the EMTALA statute itself. And so that guidance doesn't apply in Texas and to the people who brought this case. However, at the same time, essentially, that this was going on, the Biden administration had sued Idaho because Idaho's abortion ban did not include an explicit exemption for the health or life of the pregnant person. There is an affirmative defense dealing with the life, but there isn't an explicit exemption. And so the Biden administration sued, saying this violated EMTALA and federal law trumps. Now, in this case, the Idaho court ruled in favor of the Biden administration. So now you have a situation where one district court has ruled in favor of the Biden administration. The Texas court has ruled against the Biden administration in favor of the AG of Texas, and providers who, based on their best medical judgment and medical ethics, may want to provide care to a patient and under federal law believe they are required to, but under state law may fear criminalization. And that is an incredibly difficult position to put providers in, let alone patients who may be in emergency situations and won't be able to access the care they need. Now let's talk a little bit about helpers. So as we talked about with SB 8, which is the civil law in Texas, and similar copycat laws have passed in some other states, including Idaho, a helper can face civil ramifications if they help someone obtain an abortion. So again, that can be the Uber driver, that can be someone who helps provide some money. most of the criminal laws we are seeing aren't specific to helpers necessarily. However, most states have laws called aiding and abetting laws. And so the helpers can potentially fall under those in these situations. And some of the situations we're thinking about that are occurring aren't things you would naturally think about. And I want to use a letter that was sent to Sidley Austin in Texas as an example. So what happened is, like many employers, when the Dobbs decision came out, there was a lot of concern about how employees were going to be able to access abortions in states that were banning them. And Sidley Austin, allegedly, and many other employers were trying to figure out ways to ensure employees, others have access to abortion, can help pay for the abortions, travel to other states for the abortion, etc. And then the Texas Freedom Caucus sent a letter to the law firm Sidley Austin, accusing them of being complicit in illegal abortion.
Gosh.
And the argument there was that Sidley may have paid for illegal abortions or for travel because, like the situation I explained before, the medication abortions those patients were provided in other states may have been ingested, or the second drug ingested, in Texas. The caucus also advised Sidley Austin that they plan to introduce legislation to impose additional civil and criminal sanctions on entities that pay for abortions or abortion travel. So I think there's a lot to unpack there. I think, first of all, as I mentioned before, there are lots of strong legal arguments that could be made against this idea that a patient taking their second pill in Texas means that a provider or a helper or a patient violates the law. But it certainly shows that there is an effort, at least by some, to create that legal liability, and that there may be people where charges are brought on that basis. I think it also shows something that was discussed very briefly in the Dobbs decision by Justice Kavanaugh, who essentially said, well, but a state cannot restrict interstate travel. So if someone wants to go elsewhere to get an abortion, he doesn't think that would be feasible based on the Constitution. What this is showing is that states, though, will try to make it impossible for patients to go to other states by limiting their means to do so. So not allowing employers to try to help pay for these travel for the abortion themselves, etc. I also wanted to discuss pregnant persons. So people seeking abortions. So certainly the most extreme harm falls on those people seeking abortions who are not able to obtain them. And as Risa said, the impact is completely disproportional. It's going to fall on those most vulnerable, those who have also always faced systemic barriers to care. People of color, low-income individuals, etc. You are also going to see an increase in self-managed abortions, which are abortions that individuals do without the assistance of a medical professional. And nowadays, those can be very safe procedures, but you may see, as states are banning abortion and changing their laws, that there's more of an attempt to criminalize this type of behavior. Even though, as I mentioned, most of these laws don't criminalize the pregnant person, there are other ways to get at them. There was a situation in Nebraska where a young woman allegedly may have taken medication abortion pills, and she was not brought up on crimes related to the abortion ban in the state, but she was brought up on charges relating to what happened to the fetus, for example. So there are still ways to try to criminalize pregnant persons, even if they don't fall under the ban themselves. And as we talk through all that, I really want to discuss one aspect of the broader picture that I think sometimes is left out, and that's data privacy. Can we turn to the next slide? So I think data privacy is something we often don't think too much about in the context of reproductive health care. Data abuse can be extremely harmful, and in a post-Roe world, I think we really need to shine a light on it and do something about it. I will give a couple examples of how data can be used in relation to reproductive health, but there are many, many more. So one example was in May 2022, Motherboard revealed that SafeGraph, which is a location data broker, had taken the data for, I think, $160, sold it, and the data was of people who visited abortion clinics, including more than 600 Planned Parenthoods over a 1-week period, for just $160. The data showed where patients traveled from, how much they spent at healthcare centers, and where they went afterwards. And the data collected by the company included an analysis of where people appeared to live based on where their cell phones were commonly located at night. Not only is that broadly just terrifying, but that information can be used then potentially in a lawsuit if someone is trying to get information to sue someone relating to an abortion ban. One example of this to provide is the Nebraska situation that I briefly mentioned before, where a teenager and her mother were indicted this year again on multiple charges, and the mother's charges included violation of the state's law banning abortion after 20 weeks. In investigating the case, law enforcement obtained information from the daughter's social messaging app. And according to media outlets, the parent company of Facebook, Instagram Messenger, Meta, shared the information with law enforcement in response to a judicial warrant that did not mention abortion. And I know when this happened, there was a lot of outcry in the news regarding, Meta doing this. But one thing I think we have to understand is, up until now, it has been a fairly common practice for these big companies to provide data information to law enforcement when they have a judicial warrant. And so there are a lot of conversations going on right now of how do we prevent this in some of these situations if it's another state asking for this information and that care is legal if provided here. Next slide, please. So taking all that into account, I want to talk a little bit about Washington State, both because I'm a Washington State attorney and because most of what we've talked about so far relates to states where they are trying to ban abortion or severely restrict abortion. And as you saw in that map that Risa showed you and that I showed you, we also have the states like Washington State that are working to expand and protect abortion access. So just a little background on some of the laws in our state. In 1991, the Reproductive Privacy Act passed, establishing the fundamental right to choose or refuse an abortion in Washington State. And I think it's incredibly important to note that this was done by the initiative process. So the people of Washington themselves voted for this. Fast forwarding many years, and there were other big wins during that time, I wanted to talk about the Reproductive Parity Act, which passed in 2018. It requires state-regulated health insurance plans that cover maternity services to also cover abortion services. And I want to be clear here, that doesn't mean abortion is completely free, but it does mean, because maternity care is often not completely free, but it does mean there has to be some coverage provided for it if maternity care services are covered. Fast forwarding a little, you have the Reproductive Health Access for All Act in 2019. And one of the interesting things about that one that I wanted to flag is it meant hospitals had to create and post their reproductive health policies and fill out a checklist to provide the public with information about the reproductive healthcare services available. And one of the reasons I think that's important, especially as we move forward, is people need to know where they can access care. And if that's not clear, and we also have people coming from other states, things get really complicated. So it's an important step for us to have transparency in our healthcare. I will fast forward to 2021, the Protecting Pregnant Patient Act. And this actually goes back to the EMTALA discussion we were having, because as we discussed, under EMTALA, at a minimum, a hospital has to stabilize and transfer a patient. But we have seen in this state numerous occasions where patients have come into the hospital and are in need of care, dealing with miscarriages, ectopic pregnancies, and they have not been able to receive care due to, for example, the religious values held by the health entity. The ACLU of Washington put together a report of the voices of patients and providers who had been in these experiences in our state. So the Protecting Pregnant Patient Act adds another layer onto EMTALA. EMTALA is the baseline and we can have further protections. So here, unlike places like Idaho and Texas, if a patient is suffering from pregnancy complications and their health or life is at risk, or it would violate standard of care not to provide care, providers here, doctors, nurses, are allowed to provide that care, even if it's not something the entity necessarily would want. So I think here it's important that we're moving in the opposite direction of some of the states that are trying to even restrict emergency care. And one thing that I think is great to note is the Affirm Washington Abortion Access Act. It made the RPA gender neutral, the Reproductive Privacy Act that we talked about, gender neutral, and confirms that all qualified providers can offer abortion care. And importantly, Washington will not criminalize a person who has a pregnancy loss or an abortion, nor anyone who helps exercise their right to an abortion. I think this is so important because it again shows that our state is trying to move in the opposite direction. We are saying you will not be criminalized for what happens during your pregnancy and any choices you make, and anyone who helps you make them. Next slide, please. So I did my little ode to Washington state laws and some of the great things about them. But I really do want to highlight Washington is not perfect and there is a lot more we need to do, especially now that these bans are occurring around our country. I think in the past, states like Washington have often focused on what can we do within Washington for Washingtonians. But really access to reproductive health care needs to be a solution we are dealing with around the country, around the world. And so we really need to be thinking about how our laws impact others as well, especially because we will likely see an influx of patients from other states. And I know from my provider colleagues that this has already started to occur. The Guttmacher Institute had suggested in a map prior to the fall of Roe that if Roe fell, Washington may see an up to 385% increase in the number of out-of-state patients coming to Washington state. And they did that analysis based on the number of people who could become pregnant in surrounding states that were likely to have abortion bans. We do not yet know what that number on the ground will look like, but we have seen an influx of patients coming in, more from Idaho and people from far-flung states such as Texas and elsewhere. And we expect that in order to have the resources to provide care to both Washingtonians and these patients, that we will really need to bolster abortion infrastructure. Another thing that we have to be really aware of is the risk to providers and helpers of out-of-state prosecutions. I touched on this a little bit, but it is a very real concern that you hear from providers all the time right now of what can I do, what can't I do? And part of the complication with this is a lot of this is unsettled law. We're in this weird post-Roe world, and you can provide the best advice you are able to, but some of this is going to play out in real time. I also want to mention threats to clinic security that we're seeing in Washington state. I have heard from multiple clinics an increase in protesters, an increase in fears from providers. I think many protesters and others have felt emboldened post the Dobbs decision, and the impact is being seen even here. And to the point of Washington has these great laws, I also want to highlight that laws on the books don't guarantee access. There are many health systems in Washington state that refuse to provide the full range of abortion care. And so we are therefore left with limited number of places that are willing to provide this type of care, which obviously limits the amount of care that we can provide in Washington state. Similarly, when it comes to high-risk situations, when it comes to later-term abortions, there are very few locations in Washington state that are able to provide that type of care, and people sometimes have to drive hours and hours to get it. So while we have amazing laws on the books, there is still many inequities and barriers that we need to work to fix here. Next slide, please. Or just me. So to that end, I wanted to briefly discuss some of the efforts that advocates and providers and community are working on for this legislative session and beyond. So one thing I mentioned was data privacy. I think we really, really need stronger data privacy laws in relation to healthcare. Health data needs to be protected, and the data around healthcare, the location data, all of that, we need really strong protections to ensure that people in Washington and those that come to Washington are safe. I also wanted to flag funding. Funding is so incredibly important here. As I said, we're going to have to increase our infrastructure. We're going to have to make sure that when people come here to get an abortion, they have the funding to travel here, and that providers then are being reimbursed for all this care that they're having to provide. You know, these patients who come here aren't going to be on plans where Medicaid covers them for an abortion. I also wanted to flag shield laws. So shield laws are something that's been talked about. I think they began in Connecticut ever since the Dobbs decision came out. And it's the idea of better protecting providers, people seeking abortions, and helpers. It's things such as ensuring that for non-fugitive extradition, the governor will not extradite. It's ensuring that state and local law enforcement do not cooperate with investigations into care that would be legal if provided here. So if the abortion care would be legal if provided here. And it's things such as ensuring that the courts don't cooperate. The last thing I wanted to mention here is reducing barriers. It is so incredibly important to reduce barriers to care, including costs of abortion. And finally, what's happening on the federal level? I think you heard a lot about that from Risa, but I wanted to touch a little on Congress. Because along with what Biden's trying to do, Congress has been trying to take steps ever since the Dobbs decision came out. And this includes such things as the House passing a bill on the right to contraception. And the House passed the bill, and it will likely die in the Senate. I also wanted to highlight a bill that would ensure the right to same-sex marriage and interracial marriage, because again, something that's at risk after the Dobbs decision. Again, it passed the House, and there's a chance it might pass the Senate, but it hasn't done so yet. The right to interstate travel for healthcare has also come up, and again has passed the House and not the Senate. I wanted to highlight that here because while in Washington state, I think we have a good chance of advocating and hopefully passing some strong bills when it comes to reproductive health care. What it shows us is on the federal level, we are limited right now. And there's no way to overemphasize the importance of ensuring that the politicians we elect support the values we have, because if there was ever a federal abortion ban, I don't expect there to be while the Biden administration is in power, that would apply in Washington state, and all those great laws I spoke about would no longer be applicable in many instances because there would be no fundamental right to abortion in Washington state. Thank you so much.
Thank you so much, Leah. We really appreciate you and Risa sharing all of your insights, and we have a few questions that we'd appreciate your additional thoughts on. So my first question is for Risa. Given that the United States is a global outlier, what can we learn from other countries where abortion has been liberalized in the last 25 years?
Yeah, that's a great question. Thank you. It's really, as we know, the US is a global outlier. The trend is towards abortion liberalization. And inspirational, inspiring examples, particularly in Latin America. And really what we can learn, what's critical to understand, particularly when we look at Latin America, is that change comes through an integrated advocacy approach and an integrated strategy that's really grounded in a social movement, right? So the Green Wave movement in Latin America, which resulted in huge shifts in law and policy in Argentina and Colombia and Mexico, they were the result of decades of organizing and mobilizing and working to shift culture and the public narrative. And that work is essential, right? So building popular support and culture change is critical to change in law and policy, and then to preventing backlash once those gains have been made, right? So I think we really have a great deal to learn from those movements as we are seeking to rebuild towards a broader right to reproductive autonomy in the US.
Thank you, Risa. Now, a question for Leah from the audience related to data privacy. Can you talk about limitations to HIPAA protections related to abortion care and any impact this may have for providers or individuals seeking care?
Absolutely. And I will also say OCR has issued some guidance on this that I'm happy to also, let me find it in the chat as well, to send around. But one thing I really want to highlight here is when it comes to HIPAA protections, there has been, as part of the guidance put forward, information that most of what you're providing when you access or store information on your cell phone or tablets, a lot of it's not actually HIPAA protected. So when we're talking about abortion access and reproductive health care, it is such a big concern because of these loopholes, and the loopholes also when it comes to what law enforcement can obtain. This is a lot of what needs to be closed when it comes to having state data privacy laws. I will note there's also a federal law, My Body, My Data, very catchy name, that they've been trying to move forward to address some of these concerns. And I'll find that guidance.
So given the numerous abortion protections here in Washington state, do you think that having a constitutional amendment specific to Washington state will shift anything in terms of access?
That is a great question. So I think one thing that is so important for people to know is the current Washington state constitution protects the right to abortion. We have Washington state Supreme Court case law to that effect. While I think it would be even better if we had explicit language in the Constitution that called out that there is a right to abortion, I am very confident that the current Washington state protections are sufficient. And so while it is a step forward, I don't necessarily think it would change the status quo of the law because the Constitution already protects abortion.
Thank you, Leah. So given that in a number of states, people are losing access, and we've seen that around the world in countries where abortion access is prohibited, many people opt to self-manage their abortions. What have the legal risks that we've seen around the globe looked like, Risa?
Sure. So I would first point to an amicus brief that was filed in Dobbs by FIGO, the Federation of International Gynecologists and Obstetricians, and that really details the ways in which abortion bans and restrictions globally don't reduce the incidence of abortion, but rather they result in more unsafe abortions and also lead to the harassment and the arrest and the prosecution of people seeking healthcare and healthcare providers who are accused of violating restrictive abortion laws. And, you know, an unfortunate example we can point to is El Salvador, right, where abortion is completely banned and where people who are experiencing stillbirths and miscarriages are treated as suspects, particularly Indigenous women and people with low income. They're at risk of being reported to law enforcement, including by the very healthcare providers that they're seeking care from. So the Center for Reproductive Rights is working with partners in El Salvador to set people free and also to change laws there. But we know that the risks in the United States are similar, particularly for communities who are already disproportionately targeted by law enforcement. And here I would point to the work being done by national advocates for pregnant women, and if, when, how, are doing really important work in this area as well.
Well, I see we're basically out of time, so just want to thank both of you so much for offering all of this great information and for serving as our keynotes today. So thank you both. And I think I will now transition over to Leslie.
Actually, we'll be going to Abby for her presentation now. So let me, I will pull up her slide deck. Just want to make sure that we have, I believe we have some polls that we have on board. So I just want to make sure that we have those ready to go. And let me make sure we have your slides ready here.
Great. Thank you, Leslie. Just let me know when you're ready.
Absolutely, Abby. Let me see here. Okay, so we do have your slides.
Okay, and it looks like the polls are ready. I think we can get started.
Excellent.
Okay, so hi, everybody. My name is Abby. I am a senior attorney with the National Health Law Program. I use she, her pronouns. As you can see on the slide, we are a national public interest law firm working to advance the access to quality healthcare and protect the legal rights of low-income and underserved people. We have 3 offices around the country, and I am based in the Los Angeles office, so just south of most of you all. Next slide. So just a little bit of a roadmap of what I will be covering today. I was asked to speak broadly on the courts and civil rights, which is, of course, a huge topic. So here's how I focused in on it, focusing specifically on things that are of interest to health advocates. I'm going to talk a little bit about parity, talk about administrative regulations and APA, talk about Affordable Care Act litigation, and then finish by talking about the issue that's very close to my heart, which is Medicaid. Next slide. Oh, actually, let's go back. So I think let's start with the polls. I just wanted to do a couple polls just to see who's in the audience, to give me a sense of who you all are. So you should see this slide and you can tell me if you're a litigator, a policy advocate, direct services, something else. And we'll just give it a few more seconds for people to respond to that poll. All right. So it looks like we have a lot of people in the other category. So welcome, and welcome to those of you who are litigators, policy advocates, direct services folks as well. And then I believe we have another slide, which just asks you about what issues you mostly work on. So again, you can just take a couple minutes to respond, actually a couple, less than a minute, we'll say, to respond and let us know what you're working on. You only get to choose, you can choose more than one, maybe. If you can only choose one, then choose the one you mostly work on. Okay, it looks like you can choose more than one. So go ahead and choose whichever ones are most applicable. And again, it looks like we have a lot of people working on access to care, and especially some disability issues, behavioral health, reproductive and sexual health, and then a fair amount of folks working on eligibility enrollment too. So very cool. All right, so one last question. which is just what type of coverage you primarily work on. So looking to see who works on Medicaid issues like me, people who work on private coverage, BHP, ERISA, Medicare. So for this one, you just get one choice. Okay. So it looks like we have a lot of my fellow Medicaid folks here, which is great, Medicaid and CHIP, and people working in a variety of other areas too. So hopefully we'll have something for everybody. Okay, so with that, I'm going to go into my slides. For those of you who chose behavioral health, that's where we're going to start. We're going to talk a little bit about parity. Next slide, please. For those of you who don't work on behavioral health, a little background on what parity is. And essentially, it's a set of laws that require certain plans to cover that cover behavioral health services to do so in parity with their coverage of physical health services. So these parity laws don't require plans to cover any type of behavioral health services. It just says that if you do, if you choose to cover those services, you must do so in a way that's comparable to your coverage of physical health services. So many of you have probably heard of the Mental Health Parity and Addiction Equity Act. That applies to group health plans. That's federal law that applies to group health plans. And then the Affordable Care Act applied the Mental Health Parity and Addiction Equity Act to individual plans, and then sort of indirectly through guidance applied it to small group and Medicaid and CHIP. So broadly, when you're looking at parity, what you're doing is analyzing both the quantitative treatment limits that a plan applies, as well as its non-quantitative treatment limits to determine whether the plan adequately covers behavioral health services, again, comparing that coverage to what is covered on the physical health side. Quantitative treatment limits are things like refill limits on prescription drugs or day limits for hospital stays. Non-quantitative limits are more of the squishy things, things like network adequacy, things like the prior authorization process for a particular treatment, and so on. Next slide. So some of you might be thinking, you said this was about civil rights, and behavioral health parity doesn't really sound like a civil rights issue. I'm going to make the case to you that it is. Millions of people in our country have a need for behavioral health care and don't get it. So you have over 40 million people, adolescents and adults, I believe this is 12 and over, who have a substance use disorder. And 52 million, that's 1 in 5 adults in the US have a mental health condition. And this has only been exacerbated, as I'm sure many of you know, over the last few years with the pandemic, and particularly among youth, young adults, Black, Indigenous, and other people of color, essential workers, and unpaid caregivers. And there have been some really devastating news stories that you may have read about the impact that people's unmet needs for behavioral health services have had on their lives and the lives of their loved ones. Next slide. So now that I've taught you all about behavioral health parity, I'm going to talk about a case that is not a parity case. This is an ERISA case, but I'm talking about it here because it raises a lot of the same issues that come up in parity cases, and it's often a case that's referred to in the conversation around parity, even though there were not parity claims in this case per se. So this is the case called Witt versus UBH. This was a case where, or is a case, I should say, where a class of over 60,000 members in various United Behavioral Health Plan products who had been denied coverage of various behavioral health services asserted that their plan breached its fiduciary duty and acted in an arbitrary and capricious way in denying those benefits. So those are both claims under ERISA. The plaintiffs made a facial challenge to the plan's level of care guidelines and coverage determination guidelines, and argued that those guidelines did not comport with generally accepted standards of care, and thus wrongly denied coverage to many people, including adults and children. And this was a nationwide case, but filed here in California. Next slide. So where is this case now? It's currently, there is a request for en banc review pending at the Ninth Circuit. Briefing was completed this summer, so it's been sitting at the Ninth Circuit and we're waiting for a decision. Previously, the plaintiffs had succeeded at the district court and got a really great decision out of the Northern District of California back in 2019. Earlier this year, the Ninth Circuit reversed in a very short 11-page decision, and that led to that request for en banc review. And this is really the leading case on the importance of plans covering behavioral health care consistent with standards of care. So saying you can't plan, just come up with whatever standard you want to determine whether people get behavioral health services that you say are covered under the plan, but that has to have some meaning and content to it. It really has to be based on what is considered the standard of care for that service. So in terms of what we're watching for with this case next, of course, as I've said, it's waiting for that en banc decision, and that could be coming any day now from the Ninth Circuit. Next slide. So now I'll talk about real parity cases. This one is NR versus Raytheon. This case involved a Raytheon employee who had a 5-year-old who required non-restorative speech therapy to treat an autism spectrum disorder, and challenged Raytheon's practice of covering restorative speech therapy for people who lost verbal communication abilities, but not covering non-restorative therapy for people who had never developed that ability in the first place. They also alleged that Raytheon failed to provide the family with information about the refusal to cover the speech therapy. And this is a 300-person class action brought under the Mental Health Parity and Addiction Equity Act. Next slide. So this case recently reached a settlement, which is pending at the district court. Previously, the plaintiffs were unsuccessful at the district court, but then the First Circuit reversed earlier this year. And this is really important case because it confirms that parity protections may be enforced through ERISA. So where you have a plan that is an ERISA regulated plan, parity applies, and you can use ERISA as a path to enforce some of those parity protections in litigation. So what are we waiting for now? Approval of that settlement, and that case will likely be wrapping up very soon. Next slide, please. Another case to watch out for is EW versus HealthNet. This is a case out of Utah where a young woman sought treatment from a mental health provider for multiple serious mental health conditions, including 5 suicide attempts. Her insurer initially paid for her treatment, but then refused to continue paying against the recommendation of her treating providers and the generally accepted standards of care, because it determined using its own guidelines that that care was no longer necessary. And HealthNet refused to provide the processes or analysis it used to reach that decision to IW or her family. Even though her plan refused to pay, she continued receiving treatment for another 10 months. Next slide. So this case, there's an appeal pending currently at the 10th Circuit. Plaintiffs were unsuccessful at the district court level back in 2020 and 2021, both on a motion to dismiss and a motion for summary judgment. Oral argument in this case is coming up next month, so that's moving along pretty quickly. This is an important case because it really speaks to what facts you have to plead in order to state a parity violation, and also the parity disclosure requirements. And I didn't talk about this much in my intro, but you can imagine that for a parity analysis, because it's really about looking at what does the plan cover over here on the behavioral health side versus what is covered over here on the physical health side, you need a lot of information about the plan in order to make that kind of analysis. And that's not something that we ordinarily have access to from our health plans. So there is a disclosure requirement in the law that says that plans have to provide that information to people. So this case really goes to that question of, how far does that go and how can people enforce that requirement in court? So again, waiting for a circuit court decision in this case. Next slide. All right, so moving ahead, I'm going to talk a little bit about administrative regulations. Again, making the pitch that even though administrative regulations is the kind of thing that makes a lot of people, even lawyers, eyes glaze over with boredom, this really is an important civil rights issue. For one, administrative regulations are a really important vehicle for implementing civil rights laws. Congress often lacks expertise in civil rights areas, so defers to the administrative agencies to develop and implement those laws. And secondarily, it's really hard often, and we witness this every day, for Congress to reach agreement about the content of laws. And so often Congress will compromise and come up with something broader, which is easier to pass, and then leave it to the agencies to work out the details. Almost all civil rights laws do have some kind of administrative enforcement component in addition to potential court enforcement. So it's really important that way too. And of course, as I'm sure those of you who litigate know, when you are litigating, deference is due to an agency's interpretation of the statutes it implements. And so that is an important question in litigation, is what has the agency done in this area? Next slide. So big Supreme Court case from this term, West Virginia versus EPA. This is really important for those of us who are health advocates, not only because it's really a health justice issue in terms of climate and emissions, but also for its larger implications in administrative law. So as background here, back in 2015, the Obama administration had adopted the Clean Power Plan, which sought to combat climate change by reducing carbon pollution from power plants. Then in 2016, the Supreme Court put that plan on hold in response to a challenge by several states and private parties. In 2019, in response to the Supreme Court's decision, now you had the Trump administration in power, which repealed the Clean Power Plan and replaced it with a new rule called the Affordable Clean Energy Rule, which gave states more discretion to set standards and power plants flexibility in terms of how they complied with those standards set by states. Then last year, you have the DC Circuit vacating both the Trump administration's repeal of the Clean Power Plan and the Trump administration's new rule, the replacement rule, the Affordable Clean Energy Rule, and sending the case back to the EPA for additional proceedings. Next slide. So this all came to a head at the Supreme Court earlier this year, which in June, the Supreme Court reversed the DC Circuit and held that the Clean Air Act, which was the implementing statute here, did not provide the EPA with the authority to devise emissions caps. Again, this seems pretty wonky, and I am not a clean energy expert, so please don't ask me questions about those details. But in terms of the law, this is really important because the court held that the EPA's effort to regulate greenhouse gases violated the major questions doctrine, and that this is the idea that if Congress wants to give an administrative agency the power to make quote unquote decisions of vast economic and political significance, it has to say so clearly. You can already see what is a decision of vast economic and political significance. That could be a lot of things that we care about. So really, this is signaling that the court may be inclined to overturn other federal regulations in the future. And certainly, I expect we will see challenges to healthcare regulations in particular challenged under this doctrine. Next slide. So just to dig in a little bit into what is this major questions doctrine. And again, I'm sure we're going to see this fleshed out in a lot more in cases to come, but this is what we know now. There's a two-step inquiry. So first you ask, does the case trigger major questions? And to determine that, you have some non-exhaustive considerations. The majority said you want to look at whether the agency discovered a long extant statute of an unheralded power that significantly expands or transforms the regulatory authority. This is something that comes up a lot because you may have a law that was passed 20, 30, 40 years ago, and the situation has changed since then. And so the way an agency is thinking about implementing that law now might be very different than what Congress was thinking about it when it passed that law, or how the agency interpreted the statute at that time. So this is certainly something that gives me some pause. Another consideration is whether the agency's claimed authority derives from, quote, an ancillary, gap filler, or otherwise rarely used provision of the statute. Again, this is pretty subjective in terms of what is considered ancillary or rarely used, so something to watch out for. And then whether the agency adopted a regulatory program that Congress had conspicuously and repeatedly declined to enact itself. And this runs a little counter to some of the other rules of statutory construction that many of us learned in law school. So it's something to just be aware of, that if Congress has decided not to do something and an agency decides to implement a law to do something that is the same thing that Congress decided not to do, that could be a factor in determining that there is a major question inquiry. A few other factors from Gorsuch is concurrence in that decision, whether the agency claims the power to resolve a matter of great political significance. Again, who decides what is of great political significance? Unclear. Whether the agency attempts to regulate a significant portion of the American economy or requires massive spending by regulated parties. And then whether the agency's rulemaking seems to intrude into an area that is the particular domain of state law. I think all of these are, very squishy factors. So we're going to see how these play out in future cases, but something to be watching closely. Next slide. And then the second step in this two-step inquiry says that if major questions are triggered, can the agency show clear congressional authorization for its regulatory approach? Which of course just raises the question, well, how clear does this authorization have to be? And again, that is something that we will have to see how courts interpret that in future cases. Next slide. Just one other area of administrative regulation I wanted to talk about, and we'll be talking more about ACA in just a few moments. But something that you all may be watching that's certainly very pertinent to the question of civil rights in healthcare is 1557, which is the provision of the Affordable Care Act that prohibits health programs or activities that receive federal funds from discriminating based on race, color, national origin, age, disability, or sex. This is another area where you have different administrations implementing different rules and repealing rules and a lot of action in the courts. So it is an area where I'm sure we're going to continue to see litigation, and there's litigation pending now. So just as a reminder, back in 2016, the Obama administration implemented the Section 1557 through some regulations. A private entity called Franciscan Alliance sued, resulting in an injunction that stopped the implementation of that rule's interpretation of on the basis of sex. Remember that I said it prevented discrimination based on all these different things. That particular lawsuit just looked at discrimination on the basis of sex and didn't like the way the Obama administration interpreted that particular provision. So after that injunction in 2020, the Trump administration issued new rules that eliminated that definition and made some other changes. The whole slate of lawsuits filed challenging the Trump administration's rule. Next slide. So you have a few of these cases still sort of in various postures now. That original case against the Obama regulations, the Franciscan Alliance case, back in August of this year, the Fifth Circuit held that Franciscan Alliance's APA claims were moot based on the changes in the regulation since the injunction was issued, but that it might be that it could proceed on a RFRA challenge, that there may be something there under the Religious Freedom and Restoration Act. And just a reminder that the Franciscan Alliance, their concern about the definition of discrimination on the basis of sex really was wrapped up in the idea that that definition could require providers, healthcare providers and facilities to provide services they didn't like, including reproductive and sexual health services, gender affirming care. And so that was sort of the nexus of that concern. Whitman Walker Health, which was one of the challenges to the Trump administration rule, that case is currently stayed. Back in 2020, there was an injunction issued there that enjoined the rule's elimination of the definition of sex discrimination and its incorporation of Title IX exemptions, finding that those were arbitrary and capricious. So that case is stayed, and a status conference is expected later this year to determine the future of that case. You also have the Walker case from the Eastern District of New York. This was another challenge to the Trump administration rules. That case is currently stayed until 30 days after the completion of Biden administration rulemaking on 1557. And that case had just enjoined the elimination of the definition of sex discrimination. So those cases all kind of hanging out. We'll talk in a little bit about the current rulemaking process, but I anticipate we'll see movement in these cases and probably some other cases coming after that rulemaking is complete. Next slide. So again, why this is important is really because 1557 is the first federal civil rights law that interprets discrimination for federally funded healthcare programs. And it's especially important to ensuring full access to care for LGBTQ+ people, BIPOC people, people with disabilities, people with limited English proficiency, older adults, and many, many others. It applies to federally funded health programs and activities, which includes Medicaid, Medicare, providers who accept those programs, health plans that qualified health plans that receive advanced premium tax credits, and many, many more. So as I alluded to a few moments ago, earlier this year, the Biden administration published a proposed rule. The comment period on that proposed rule closed fairly recently, so we expect a final rule soon-ish, and also expect further litigation when those final rules do come down. Next slide. All right, so we already started talking about the Affordable Care Act, but we can dig into it a little bit more. Why is the Affordable Care Act a civil rights issue, you may ask? I would argue that it is a really important civil rights issue because it made health coverage and, as a result, health care accessible to millions of Americans and people in this country for the first time. As we just talked about, it does bar certain forms of discrimination in healthcare and begins to address some of the effects of longstanding discrimination and health disparities that we have seen in this country for many, many years. So a quote here from Louise Melling at the ACLU: "By providing coverage for healthcare for all people in need, it enables the freedoms of other civil rights laws aimed to protect. Simply put, it is not possible to fully participate in the economic, social, and civic life of our nation without stable health coverage." Next slide. So let's talk about what's happening in ACA litigation these days. A case many of you may have heard about, Braidwood versus Becerra. And this was is a challenge to the preventive services provisions of the ACA. Those provisions require individual, small group, large group, and self-funded group plans, so almost all plans, to cover certain preventive services without cost sharing, including those given an A or B rating by the U.S. Preventive Services Task Force. And one result of that provision is that plans have to cover pre-exposure prophylactics, or PrEP, to prevent the transmission of HIV. A group of employers who don't want to cover PrEP for their employees and also don't want to cover other preventive services, including contraception, HPV vaccine, screenings and behavioral health counseling for sexually transmitted infections and substance use, sued. Next slide. So just last month, a district court in the Northern District of Texas found that the ACA's preventive service requirement to cover services recommended by the U.S. Preventive Services Task Force violated the Appointments Clause, and that the plaintiffs had stated a claim that the requirement to cover PrEP in particular violated the Religious Freedom and Restoration Act, or RFRA. So just to note, this is a pretty technical area of the ACA. There are various parts of Section 2713. So there were other parts that the court found were appropriate, but particularly the recommendations by the U.S. Preventive Services Task Force. The court found that task force had not been appropriately appointed under the Appointments Clause to make the binding recommendations for preventive service coverage. And so that's what's kind of at issue in that case right now. This is important because this has been such a crucial provision of the Affordable Care Act that ensures people have access to a wide range of preventive services, and PrEP in particular, which is 90% effective in preventing HIV transmission, is recommended for adults at high risk of HIV, which includes a lot of gay and bisexual men, transgender women, and especially those who are of color. So this case is really pending right now. I was hoping that originally there was going to be some briefing filed in this case this week, but the parties got an extension, so that will come in next week. So we'll know a little bit more about where that case is going. But there's additional briefing requested on whether some of the plaintiffs, as I mentioned, there's a group of employers who filed the suit, whether they have standing. And then also the question of remedies. Now that the court has found that the Preventive Services Task Force violates the appointments clause, what is the appropriate remedy? And then certainly, once sort of this round of the case wraps up, we expect that there will be appeals. So keep watching that one. Next slide. 1557 we talked about earlier in terms of sort of the APA and the regulations, but I also wanted to talk about some affirmative 1557 litigation. So one is the Doe's v. CVS case that was at the Supreme Court last term. This is a disability discrimination case where a group of people with HIV challenged CVS's prescription drug plan, which only covered specialty medications when delivered by mail. And so people, if they wanted to pick up their prescription at the local pharmacy, they had to pay out of pocket for it. The plaintiffs there argued that the policy prevented them from receiving needed health care and thus represented discrimination based on their disability under 1557. Next slide. So the Supreme Court had accepted cert for this case last year after the Ninth Circuit held that the plaintiffs had stated a claim for a violation of 1557. This was at a motion to dismiss posture. But sort of at the 11th hour, the parties reached a settlement and dismissed the Supreme Court appeal. So the Supreme Court did not make a decision in this case ultimately. And this is important because the Ninth Circuit opinion would allow people alleging disability discrimination under Section 1557 to challenge a facially neutral policy as discriminatory on a disparate impact theory. And so this goes to how we conceptualize, what constitutes discrimination and what level of proof do you need in order to state a discrimination claim under Section 1557, something that almost certainly there'll be more litigation about in the future. Like I just said, in terms of what to watch out for, there's going to be more litigation about the scope of claims and disparate impact in particular. There may be decisions in other circuits which could lead to a circuit split, and this could very well end up back at the Supreme Court in the future. Next slide. Another recent Supreme Court case is on the remedies available under Section 1557. Cummings versus Premier Rehab. This case involved Jane Cummings, who's deaf and legally blind and primarily communicates using ASL. She sought care from Premier Rehab, which declined to provide an ASL interpreter at her physical therapy appointments. She alleged that that constituted prohibited disability discrimination under Section 1557. The district court dismissed her complaint, finding that her only compensable injuries were emotional harm and that those type of injuries were not recoverable, or those types of damages were not recoverable under Section 1557. The Fifth Circuit affirmed. Next slide. In April of this year, the Supreme Court affirmed the Fifth Circuit, holding that the only remedies available under 1557 were those that the recipient of federal funds were on notice that they could be exposed to that type of liability. So they used sort of a contract theory there. And this is important because it really limits what damages are available under Section 1557. Often in these cases, the compensatory damages are very minimal. Really, the injury of discrimination is the emotional harm. And unfortunately, now it will be much harder for people to recover for that kind of discrimination and the kind of harm that they've experienced. So continue to watch for future litigation about this. Next slide. One other case from 1557 about the scope is TS versus Heart of Cardon. This was a case where a child whose parent worked for a nursing home and is covered under the employee health plan sought treatment for an autism spectrum disorder, but the plan refused to cover that treatment because it excludes coverage for autism and other pervasive developmental disorders. The Heart of Cardon, the defendant there, argued that because it was the litigant was the dependent child of its employee, he was not within the zone of interest that 1557 intended to protect. Next slide. So earlier this year, the Seventh Circuit affirmed that TS was entitled to sue. And this is really important because it makes clear that 1557's protections extend not only to the healthcare programs and activities, but also to employee health plans. This is an issue that is in the proposed regulations that I mentioned earlier, and for sure there will be more litigation about it. Next slide. Let's skip over the gender affirming care cases because I know we want to get to Medicaid before we run out of time. And we'll talk a little bit about that in the Medicaid context. So Medicaid is a civil rights issue. I know there are a lot of people working on Medicaid issues here today, so hopefully you already agree with me, but for those of you who aren't as familiar with Medicaid, over 82 million low-income people get their healthcare through Medicaid, and almost half of those are children. It is a major source of coverage for BIPOC, LGBTQ+, seniors, people with disabilities, and people with chronic conditions. Next slide. So this is the big Medicaid case that's pending now that I know we wanted to make sure we had time to talk about today. Health and Hospital versus Talevsky. This is a case where Georgie Talevsky was receiving care from a skilled nursing facility and alleged that that SNF violated his rights under the Federal Nursing Home Reform Act. The district court dismissed his case, finding that the act, which is a spending clause law, was not enforceable under Section 1983, which is the Civil Rights Enforcement Statute. The Seventh Circuit reversed, holding that he did have the right to enforce. Next slide. So this case is currently at Supreme Court. It granted review back in May to consider whether, in light of the compelling historical evidence to the contrary, the court should re-examine its holding that spending clause legislation gives rise to privately enforceable rights under Section 1983. So this is really important because this case is not just looking at that Federal Nursing Home Reform Act, but all of spending clause legislation and whether those types of laws can be enforced under Section 1983. If the court says that they can't, that is going to bring an end to decades of enforcement of the Medicaid Act, which is very close to my heart, but also other spending clause laws in federal court. So this case is set for oral argument in a few weeks, and we expect a decision next year. Some of you may have seen in the news, there was a push to try to get the Health and Hospital, the skilled nursing facility, which is operated by a county in Indiana, to try to get them to back out of the Supreme Court case and see if, like the Doe's versus CVS case that I mentioned earlier, that they could reach an agreement so that the Supreme Court would not have to reach this issue. And unfortunately that failed. So there are still some efforts to try to get this case away from the Supreme Court, but the closer and closer we get to oral argument and the decision, the less likely that is. So that's the big scary thing in Medicaid that's hanging out there. Next slide. Next slide. Let's go to the next slide. Yeah, let's talk a little bit about the gender affirming care cases, and then we have maybe time for one or two questions. So not an issue in your state of Washington, but in many states, Medicaid programs don't cover gender affirming care for transgender and gender diverse people. Sometimes those are the result of longstanding policies, and sometimes there are new policies that are being enacted now in some of the red states where there is a lot of animosity towards LGBTQ+ people. And beneficiaries in these states have challenged the exclusions both under the Medicaid Act and Section 1557 of the Affordable Care Act, also under the Equal Protection Clause of the Constitution, I should say. Next slide. So just to let you know that some of these cases have resulted in injunctions and settlements. There are two cases that are kind of working their way through the courts now. Fain versus Crouch, which is a West Virginia case. The appeal has been docketed, so they were successful at the district court and the appeal has been docketed. And then Decker versus Marstiller, a Florida case. It says PI currently pending, but actually the PI was denied last week. So that case will continue to move forward in Florida. And these are really important cases because, especially as you heard at the keynote, these types of litigation are going to be really necessary as states use Medicaid as a way to fight against LGBTQ+ and reproductive rights and restrict access to those necessary services in their Medicaid programs. So we'll keep watching those cases, and there may be other similar cases popping up soon. So I think I'll stop there and just see if there are any questions.
Thank you, Abby. This is a whirlwind, and unfortunately, a lot of it is really shocking. And you know, I know it's hard to be the bearer of difficult tidings, but we really appreciate your efforts and HELP's efforts in watching these cases and getting involved as you have often to try and mitigate or get more positive results. As I don't see any questions in chat, I do have, or in the Q&A, looking around to see if we're missing any, but I do have one for you. Going back to Talevsky, just for the benefit of the audience, Talevsky is about enforcing Medicaid rights, and it's, as some of us who specialize in this area know, it's just a really significant and worrying case, because many other cases in the past have been about enforcing Medicaid rights by individuals. Can you talk about some examples of how Section 1983 has been used in the past to enforce Medicaid enrollees' rights?
Sure. I mean, certainly in the context I was just talking about, gender affirming care, we litigated a case in Wisconsin that affirmed the right to gender affirming care under Medicaid's availability and comparability provisions. So those are two specific provisions of the Medicaid Act. One that says, you know, you're entitled to the services that are covered in your state Medicaid plan, and those services have to be available in a sufficient amount, duration, and scope. And then also comparability, which says if your state Medicaid plan covers a service, it can't have a discrimination on the basis of diagnosis for that service. So it can't cover it for people with one illness or condition and not cover it for people with another illness or condition who have an equal need for that service. So those are two provisions that have a very good enforcement track record in the courts under Section 1983 and have been used in a variety of different contexts. I mean, from gender affirming care to incontinence briefs, durable medical equipment, prescription drugs, and that type of federal litigation would no longer be possible if the Supreme Court rules that you can't use 1983 to enforce the Medicaid Act and other spending clause legislation anymore. So that's a pretty grim note.
Thank you. And those are great examples. And I just want to emphasize that this goes back decades. I mean, this is really ever since the beginning of Medicaid that people have been able to challenge improper applications of the law. So and there have been restrictions over the years.
It's true. It has been
applied.
An area where the courts have been slowly chipping away. You know, you used to just be able to bring a case that said violation of the Medicaid Act without being specific at all. That won't fly anymore. So really, we've seen courts really view Medicaid Act litigation with a lot of suspicion. And I think that comes from a concern about, you know, really an animus against poor people and people who rely on Medicaid to get the healthcare services they need.
Yes, unfortunately, that's the case. But you would think that with all the restriction that's already happened, that we wouldn't need a case like this to totally take it away. We do have one other question. So thanks. Great presentation. Thanks to NHELP. And does Abby have any predictions on family glitch litigation?
Family glitch is not my area of expertise, so I don't want to make predictions. There is a fix that is pending right now, so it may not be, there may not be a need for litigation, I guess, depending on what happens there. But I won't wander too far out of my area of expertise to make any predictions beyond that, I guess.
And would this be a congressional fix that you're talking about?
I believe that is regulatory.
Oh, okay. Well, let's all hope, because our state, we had a presentation earlier in the day from Joan about what the exchange is doing to do away with the family glitch and start enrolling people during this open enrollment. So sometimes the timing of these things is just very disruptive to how the agencies want to move forward. Well, I want to thank you so much for your presentation. This has been really wonderful, and your slides are super informative. So thanks for spending the time to make it a really tight presentation. We really appreciate it. And we are now ready for our next break, which will be 15 minutes. And when we return, we'll have a look at how Washington State is addressing medical debt with representatives from the Office of the Insurance Commissioner and the Attorney General's office. Also wanted to remind people to look in the chat if you are claiming CLE credit for the links to attendance reporting. You have to fill out the course attendance no matter whether you're doing partial or full. And then if you are doing partial credits and you're not able to attend for the full day, there is an attendance report form. And just a reminder that in that situation, there will also be a recording available to listen to what you've missed. So thanks, and we're ready for a break.
Just a minute, everybody. Thank you for joining us for Washington's progress on addressing medical debt. An estimated 5% of Washington residents are being chased by medical debt collectors, with higher rates among communities of color. Many more Washington residents remain uninsured or underinsured, with health insurance premiums and deductibles consuming an ever greater share of income. Though healthcare prices continue to rise, 2 new policies went into effect over the summer that will give Washington residents some welcome relief. Starting us off to discuss the Balanced Billing Protection Act, or BBPA, is Jane Beyer, Senior Health Policy Advisor in the Washington State Office of the Insurance Commissioner. Thanks for joining us, Jane.
Happy to be here. So hello, everybody. While Leslie's getting the deck up, we can go to the next slide. And I want to talk to you today about recent legislation, both state, which was actually, we had one bill that was enacted during the 2019 session and another that was just enacted this past session, and federal legislation related to surprise billing, or what we call balance billing. And the one thing that's great about this slide is that it's in the past tense. Surprise billing happened, not happens. And just to give you a sense of some of the really compelling consumers that we worked with when we were working on the legislation back in 2019, clearly these are situations where consumers lack choice of who their providers were going to be. One was a mom who took her son to an in-network hospital. Her son was transferred to an out-of-state, out-of-network children's hospital, and she landed with a bill of $96,000, only half of which was paid by the carrier. Another very much more recent one was an air ambulance billing that resulted in a balance bill of $12,000 after a carrier had paid $18,000. And another, and probably the most common circumstances that we saw with respect to balance billing, were planned surgeries at an in-network hospital where the consumer chose the hospital, chose the surgeon, and then lo and behold, received bills for thousands of dollars from an out-of-network anesthesiologist. Or they went into an emergency room at an in-network hospital and then lo and behold received balance bills from the emergency room physician who was contracted with the hospital or contracted to staff the hospital ED, but was still out of network with the individual's carrier. Next slide, please. And so what did surprise billing mean? It meant costs to the healthcare system, in addition to the impact on consumers. And basically, the ability of providers to balance bill meant that health plans, especially self-funded health plans or Taft-Hartley plans, would end up paying the full bill charges to the out-of-network provider because they just didn't want to expose their employees to that level of financial harm. And next slide. And equally important, the ability to surprise bill essentially provided an opportunity for providers to negotiate higher in-network payment rates. And what they would use as leverage is their ability to balance bill. And some of the data that's in here would reflected average contracted commercial payment rates for, you could see anesthesiologists 3 times Medicare, emergency medicine 3 times Medicare, whereas across all physicians, the average in-network rates were more like 125% of Medicare. And all of that, as we know, gets built into premium. Next slide, please. So, new world, thank God. The Washington Balanced Billing Protection Act, as I indicated, was originally enacted in 2019. It went into effect January of 2020. And importantly, our comprehensive law and comprehensive laws in about 15 other states are considered a quote unquote specified state law under the federal statute. So Congress managed in 2020 to enact the Federal No Surprises Act, and they were fully aware of the fact that a significant number of states had already legislated on their own on this issue. And the Federal No Surprises Act went into effect on January 1 of 2022 and essentially acknowledged the fact that those states that already had comprehensive laws could maintain pieces of their law as long as the state law was as protective of consumers. And because we ended up in a situation where we had 2 different statutes governing the same conduct, this past session, we asked the legislature to pass a statute aligning the BBPA and the NSA, but retain key BBPA consumer protections. And NOLA was super active and super helpful in our deliberations on the legislation. Next slide, please. So many of you know the Washington, our healthcare system is complicated. And so one of the first things that we always have to talk to folks about is when legislation passes, which types of health plans it applies to. So the BBPA, the state law, applies to fully insured health plans sold in Washington state, which includes plans, the QHPs that are sold through the exchange. It applies to our state employee health plan, PEB, and our school employee health plan, SEB, but also back in 2019 when we passed our law, because at that time, self-funded group health plans didn't have a way to protect their enrollees from balance billing. We said to self-funded group health plans, y'all come if you want to opt in and provide these protections to your employees. We're more than happy to have you participate in our state law. And lo and behold, we've had about 380 self-funded group plans that have opted in, which is about 500,000 lives. And so for other plans that are out there, so self-funded group health plans that have not opted in to the BBPA, the No Surprises Act is essentially the baseline. And it's probably almost a couple of million people in Washington state. And then most of you probably already know that balance billing was already illegal under the Medicare and the Medicaid program before Congress passed the No Surprises Act. Next slide, please. So let's talk about what services are protected from balance billing. Emergency services. Most importantly for emergency services, and I know one of the earlier speakers referenced EMTALA, so you'll hear me refer to EMTALA in this presentation, but emergency services must be covered whether the provider is in or out of network and without prior authorization. In addition, a group health plan or a carrier cannot go back after the fact and look at a diagnosis that was ultimately given in the emergency room and say, oh yeah, I know this person thought they came in with a heart attack, but they really only had heartburn. So no, we're not going to cover this because it's out of network. The feds in rules and the preamble to the NSA rules made very, very clear that the carriers cannot do that. And what is significant about the No Surprises Act is under EMTALA had always said hospitals have to screen and stabilize an individual. Once they were stabilized and could safely be transferred, then the group health plan or the carrier could require that the person be transferred. Significantly, the NSA extended emergency services to include post-stabilization services. And the statute defines these services as observation or an inpatient and outpatient stay with respect to the visit during which the emergency screening and stabilization services were provided. And for those of you who have done consumer advocacy for consumers around EMTALA and emergency services, there are often disputes about at what point a patient was stabilized. Well, now we have a concept of post-stabilization. The federal agencies in implementing the NSA did not choose to provide additional guidance related to what post-stabilization meant. So I am going to anticipate that as we move forward with NSA and BBPA sort of round 2 implementation, that this is an area that there could be some potential disputes between consumers and their health plan. Next, please. So what care settings do these emergency services protections apply in? For all health plans, including self-funded health plans, the protections apply in hospital emergency rooms and freestanding emergency departments. And what is significant is in FAQs that the federal agencies issued in October, they gave states the ability to also extend these protections to services that are provided in behavioral health crisis facilities. And if anybody wants sort of the background on how that happened, I'm happy to provide it, but I want to try to keep moving forward here. The significant thing being that many of us know that an emergency room is often the worst place for somebody in a behavioral health crisis, especially a child. And so as the state implements our 988 system that Amber talked about earlier, and we sort of start to bring up more and more behavioral health crisis services, it provides an alternative for consumers, and the balance billing and emergency services coverage protections apply in those settings. The one area where state law goes beyond the NSA, so for fully insured plans, the protections also extend to services that are provided by mobile rapid response crisis teams. And we can talk a little bit about that if we have some extra time. Next slide, please. And here is a nifty chart or a table that basically lays out the services that are protected, when those services are protected, in what facilities, and what kinds of providers. And what is most significant is, number one, air ambulance services. Under federal law, states could not regulate air ambulance provider rates. And so Congress took that on in the No Surprises Act. So like that example that I gave you at the beginning, no more $12,000 balance bills for air ambulance services. And for non-emergency services, the BBPA had limited balance billing protections to a subset of non-emergency services that were provided at in-network hospitals or ambulatory surgical facilities. And Congress and the NSA actually expanded that scope of protection. So we incorporated that into the BBPA in the legislation that just passed. so that any service or item furnished to a consumer by an out-of-network provider at one of these in-network facilities is protected from balance billing. And it includes lab and imaging services that initiate at the hospital or ambulatory surgical center, but might be sent out to an outside lab or an outside radiologist for analysis. So super, super good to see that Congress was so broad in its protection on non-emergency services. Next slide, please. So what happens, what are the protections for consumers? Here is one situation in which Washington State exceeds the protections in the No Surprises Act. So for health plans that are subject to the BBPA, consumers cannot be asked to waive their balance billing protections. Under the No Surprises Act, there is a provision that in limited circumstances allows a provider to ask a consumer to waive their balance billing protections. And so now for those self-funded health plans that have not opted in to the BBPA, there can be notice and consent sought. But most importantly, in terms of messaging to consumers, a carrier cannot require a consumer to waive their protections. However, a provider. But a provider can say to a consumer, if you are not, for example, for a surgeon for a planned surgery, a provider can say to a consumer, if you don't consent to my balance billing you, then I'm sorry, I'm not going to be your surgeon. So that was one of the really troubling aspects of the No Surprises Act that fortunately the legislature was super supportive of not incorporating into state law and keeping the prohibition in state law. Next slide, please. So what other protections go along with the balance billing prohibition? Essentially, from the consumer's perspective, it is as if I received an in-network service from an in-network provider. My cost sharing is the same as if the service had been received from an in-network provider, and there's a mechanism in both state and federal law, the same mechanism to calculate, for example, when a consumer has 40% coinsurance or 20% coinsurance, how that's calculated. Cost sharing must be applied to the consumer's deductible and out-of-pocket limit. And for plans that are covered by our BBPA, any consumer overpayment must be refunded to the consumer with interest. Next slide, please. So if a consumer receives what may be a surprise bill, here's what we advise folks to do. Don't pay it right away, but also don't put it in a desk drawer and forget that it's there. Contact your health plan and ask, has my deductible been satisfied? Because often when there's a big bill, it's because a person's deductible hasn't been met. And then also ask, what would in-network cost sharing be for this service? Because that's the applicable cost sharing. And if, based upon the information from the health plan, it looks like it could be a balance bill, that's the point to contact the provider and say, hey, I think you balance billed me and that's not kosher. You can't do that. And if consumers don't get relief from the provider, then we ask them to file a complaint with us. And if it's a self-funded group health plan that hasn't opted in, or even if it's a fully insured plan, they can file a complaint with CMS at the link that's provided in the material. Next section or next slide. Oh, we can, I apologize. I mistakenly put this slide into the deck, so we can pass that one. So we have updated we have a standard notice of consumer rights that carriers and providers had to begin using as of May of 2022. If any of you have had any kind of a planned procedure or surgery at an in-network hospital or ambulatory surgical facility, you should have received this notice of your rights, both at the point at which the facility scheduled your procedure, and then also when the care was authorized by your carrier. So hopefully, I know I received it, so that was good. Next slide, please. So what we wanted to do also here was try to have a simple way to say when a consumer needs to get a notice of balance billing protections. So the consumer needs to get this from providers and facilities when they schedule non-emergency services. Again, that's what we require in state law. Within 72 hours of a consumer receiving emergency services, again, we require that under state law. And then also under the No Surprises Act, when a provider or facility requests payment from a consumer, or if they're not billing the consumer on the date they submit the claim to the carrier or the health plan. And then on the carrier side or the health plan side, under the BBPA, again, as I indicated earlier, when a carrier authorizes non-emergency services for a consumer, and under both the BBPA and the No Surprises Act, basically, when the carrier sends a consumer their explanation of benefits, their infamous EOB, that notice needs to be in there when it's a service that's subject to balance billing protections. Next slide, please. So let's talk a little bit about consumer cost information. This provision is a provision of the No Surprises Act. And essentially, Congress wanted to provide an opportunity whenever a consumer was scheduling an item or service for an uninsured or self-pay individual, and or a consumer requests a good faith estimate. The provider has to provide the good faith estimate. And unlike the balance billing prohibitions, there is no specific specialty or facility type or site of service that's exempt from this requirement. And the tricky part is that the provider then needs to say, are you uninsured or are you self-pay for this service? So for example, will the individual not be submitting a claim for the service? Because sometimes if, for example, you have somebody who's enrolled in a bronze plan through the exchange and has a relative, or even a silver plan through the exchange and has a relatively high deductible, and let's say they need an x-ray, they might go to the provider and say, hey, what's your cash charge for this? Because in fact, the cash charge might be lower than what the consumer's cost sharing would be, and or the consumer having to pay the full amount out of pocket because they hadn't met their deductible yet. And in a situation where a provider provides a good faith estimate and then the consumer gets the bill and the bill is $400 or more than the good faith estimate, there's a patient provider dispute resolution process that's built into the No Surprises Act. And I sent you some links to recent FAQs on this provision. Next slide. So now let's talk about the advanced explanation of benefits. This is for individuals who are insured and who do intend to submit a claim for coverage. So what ends up happening in this case is the provider sends the good faith estimate to the insured individual, and they also give that information to the carrier, so the carrier can prepare what's called an advanced explanation of benefits and get that to the consumer. And this is subject to notice and comment rulemaking, and both the federal government and we deferred enforcement of that requirement until federal rules were adopted, in part because of the great complexity of figuring out standard ways for providers to electronically transfer that good faith estimate information to carriers and health plans. But it's coming. I think if I remember correctly, the federal agency recently put out a request for information to help inform their rulemaking on this issue. Next slide. So let's talk about enforcement. When it has to do with an action taken by a carrier, we have authority to enforce not only the BBPA, but also any of the provisions of the Consolidated Appropriations Act of 2021, which includes the No Surprises Act. We always encourage consumers to file complaints with us if they believe their health plan may have violated the law. And then for self-funded group health plans, it is the federal government, the CMS, that is enforcing the provisions of the No Surprises Act. And again, I put the No Surprises Act help desk complaint link in there. Next slide, please. Providers and facilities, this is more complicated. Under the Balanced Billing Protection Act, and this took a long time to negotiate with the provider groups, illegally balanced billing a patient is unprofessional conduct under the health professions licensure laws, and is also a violation of licensure rules for hospitals, ambulatory surgical centers, behavioral health emergency services providers, and medical labs. And we had many discussions with DOH and the disciplinary authorities. And what we agreed was that where a consumer contacts us and they say, I think I got a balanced bill, we will contact the provider or facility to give them an opportunity to cure. And if the provider or facility does not cure what we think is a violation, we have the ability to refer those for disciplinary authority for enforcement. Under the No Surprises Act provisions, the Department of Health and the Medical Commission and the other disciplinary authorities are enforcing the provisions related to providers, but they have delegated enforcement of provisions that apply to facilities, to the CMS, to the Centers for Medicare and Medicaid Services. So it's sort of messy and bifurcated, but when it comes to a consumer thinking they've been illegally balance billed, we would recommend that the first place they come is to us. Next slide. So what's consumer experience been? Since the BBPA was implemented in 2020, we've actually received only 11 complaints about providers balance billing people. We always know that the number of complaints that we receive is less than the extent to which a practice is happening out there already. In all of those cases, we contacted the providers regarding possible violations. And in all of the cases, the providers either waived the bills or refunded any payment that the consumer had made. We've also gotten complaints regarding carrier BBPA compliance, and they often involve claims processing or delays or questions about cost sharing. And when we get those complaints, we will go directly to the carrier to investigate them. And since we implemented the BBPA, our consumer affairs folks have referred 6 cases to our compliance folks in the agency for investigation of possible BBPA violations. And then again, complaints regarding self-funded group health plans that have not opted into the BBPA can go directly to the No Surprises Act. I did a little bit of searching and not super extensive because of time limitations, but we do not have easily findable data regarding the number of complaints that have been submitted to consumers from Washington State. Next slide, please. So, given the fact that providers cannot balance bill consumers, a major issue has been provider and carrier dispute resolution. And until July 1, 2023, or a later date determined by OIC, essentially what happens is the carrier, when they get a bill from the out-of-network provider, pays the out-of-network provider what is considered a commercially reasonable amount. And if the out-of-network provider does not think that the amount that they were sent by the carrier is appropriate, they can negotiate for 30 days. And if the provider is still not satisfied after negotiation, they can request arbitration. The arbitration is a variation on the Uniform Arbitration Act at Chapter 7.04A of the RCW. The parties split the cost of the arbitration. Each party presents a final offer with justification for why they think their offer amount is the most commercially reasonable amount. Most notably, billed charges, the provider's billed charges are not a factor that the arbitrator must consider. The arbitrator then chooses one party's offer or the others, and that decision is final and binding on the parties. As of July 1, 2023, or as I indicated, a later date determined by OIC, we will shift and we will use the No Surprises Act dispute resolution system. And one of the reasons that we chose to delay moving to the NSA was the significant amount of litigation that has been going on related to the design of the No Surprises Act independent dispute resolution system. And we can talk about that a bit more if we have time. Next slide, please. So, okay, great. So there is an extensive, Leslie, you can go back to the appendix. There is an extensive appendix in here with a bunch of other information on other consolidated Appropriations Act provisions that we think might be of interest that relate to consumer protections. There's more information on the BBPA as well. So I hope that was helpful.
That was great, Jane. Thank you very much. So let me just ask you one quick question before we ask Audrey to present, and that is, if you could just summarize very quickly, what are the key takeaways that attorneys should take from your presentation?
So key takeaways are basically, if a consumer contacts you about a bill that just seems like it's not right, it might not be right, and it could be balance billing. And so I would always look for that. And then the other one is always to be sure that the consumer's cost sharing has been calculated correctly, and that that it's been treated just like an in-network claim. And as I mentioned earlier in the presentation, I could foresee some disputes coming up around post-stabilization care. When does it end? So.
Great. Thank you. Well, we will be now welcoming Audrey Udishen from the Attorney General's office. She's an Assistant Attorney General who leads the Consumer Protection Division's healthcare practice. She'll be discussing charity care. That's free medical care for people who are uninsured or underinsured.
Hi, everyone. Let me try sharing my screen. All right, is that working?
It certainly is.
Okay. Well, thank you, Leslie, and thanks to NOLA for having me to talk about the Attorney General's office charity care work. So over the last 6 or 7 years, the AG's office has been really active in the charity care space, both on the law enforcement front and also recently on the legislative front. And I'm going to briefly discuss our work, starting with our law enforcement work. So in 2017, the AG's office brought 2 charity care lawsuits. One was brought against Franciscan Health System, which many of you may know as CHI Franciscan, which operates a number of hospitals in South King, Pierce, and Kitsap County. We also brought suit against Capital Medical Center, which is a small for-profit hospital in Olympia. Those cases resolved with public consent decrees in 2019 and 2020, with significant restitution to consumers in the form of refunds and debt forgiveness and binding injunctive terms. Then in February of this year, we brought suit against all of the Providence affiliated hospitals in Washington. So that includes all Swedish hospitals in Washington, all Providence, all of the kind of various Providence hospitals, primarily in Southwest Washington. There's one in Everett and then a number of them in Eastern Washington, and Hadlack Regional Medical Center in Richland. In these cases, we allege that the Providence hospitals violated the Consumer Protection Act by engaging in practices that obscure or conceal the availability of charity care from low-income consumers and promote the deceptive net impression that consumers have no option but to pay out of pocket for their hospital care. The case is pending in King County Superior Court. And then this summer, we amended our complaint twice to add claims against two of Providence's debt collectors. One is called Optimum Outcomes and one is called Harris & Harris. We allege that Providence's debt collectors failed to provide disclosures required by the Collection Agency Act related to the availability of charity care to consumers that are in debt collection and consumers' rights to request information about their hospital accounts. Violations of the Collection Agency Act are automatic or per se violations of the State Consumer Protection Act. Our factual allegations are complex, but I'm going to try to kind of hit some high points and give a quick overview of our factual allegations in these cases. So, the main thrust of our allegations is that Providence engages in a number of practices which don't put consumers fully on notice of the availability of charity care, and then in many cases of their own actual eligibility for charity care. So we allege that Providence fails to screen patients for charity care eligibility before attempting to collect payment from them, which is required by our state Charity Care Act, which is at RCW 7170. We allege that Providence doesn't meaningfully notify patients of the availability of charity care. And then we allege that they use collection tactics that are designed to give patients the impression that their only option is to pay for their care out of pocket. So you can see the graphic on the slide here. This is part of a collection training that we allege Providence distributed to its staff members. And you can see this gives the staff member direction on how to request payment from a patient. So you can see it says, first you state the amount the patient is owed, or excuse me, the patient owes. Then you immediately transition into listing the acceptable payment method. So essentially saying, we accept cash, check, credit card. And then you ask, how would you like to pay that today? And the scripting makes clear that that last sentence is used to create the impression that payment is expected, right? So you don't say, can you pay today? Are you able to pay today? And so it makes clear this scripting is chosen for very specific reasons. This next slide is a continuation of the same collection scripting, and this trains staff on how to respond if a patient declines to pay for their care out of pocket. So staff members supposed to ask, how would you like to pay today? And if the patient declines, the staff member is supposed to not accept the first no. They're supposed to continue to keep pressing for payment. So if a patient declines to pay the entire amount requested, staff member is supposed to ask, well, can you pay 50%? If the patient says no to that, then staff member is supposed to say, can you set up a payment plan? And only then, if the patient rejects that final option, are they to then educate the consumer on their charity care rights. So you can see how this could be framed as a deceptive trade practice under our state consumer protection law, because it's concealing the availability of charity care to consumers until they've rejected a number of different payment options. They have another set of claims that I won't go into too much detail here, but they relate to Providence's post-treatment billing and collection practices. And kind of in short, Providence uses a tool that, and a lot of hospitals use these kind of tools where they're offered by credit reporting agencies, and they can project or estimate consumers' income based on their credit score and other publicly available data. And so before sending accounts to debt collectors, Providence runs some patients through this tool, and it identifies patients who are potentially charity care qualified. Providence writes off some of those accounts, but doesn't notify consumers that they've been identified as likely charity care qualified. So we allege by not providing that information to consumers, they're then preventing consumers from advocating for themselves or family members the next time they're in a hospital for care. We also have another set of claims about Providence's failure to actually extend charity care to consumers that are identified by that tool as income qualified for charity care, and failure to write off the accounts of Medicaid beneficiaries, and in fact, sending the Medicaid beneficiaries on to debt collectors. I am going to transition into our legislative work. So in the 2020 legislative session, the Attorney General's office requested legislation that ultimately passed that raised income eligibility for charity care in the Charity Care Act. So prior to this amendment, in statute, charity care eligibility was capped at 200% of the federal poverty guidelines. A lot of hospitals did provide charity care to consumers above that 200% FPL cap, but it was haphazard. Some of the bigger, wealthier systems provided more, provided charity care to higher income consumers. A lot of rural consumers living in more rural areas who were above the 200% cap didn't have access to charity care. So the purpose of the legislation was to streamline, first of all, just to raise charity care income eligibility, which hadn't changed since the advent of the statute in the 80s, and to provide some uniformity across the state in terms of eligibility. You can see on the slide that the legislation ended up creating a two-tier system where health systems that operate 3 or more hospitals, with a couple of exceptions, operate where they provide 100% charity care to consumers at or below 300% of the federal poverty guidelines, and then sliding scale charity care to consumers with income between 300% and 400%. And then health systems that operate less than 3 hospitals do 100% charity care to consumers up to 200%, and then sliding scale between 200% and 300%. The other important thing that the amendment did was to kind of add some necessary guidance around asset consideration in charity care analysis. So before the amendment, the charity care regulations authorized the consideration of assets for consumers with income above 100% of the federal poverty guidelines. The amendment moves that up to 300% of the federal poverty guidelines. So meaning consumers with income less than 300% FPL, hospitals cannot consider their assets at all in determining if they're charity care eligible and how much to extend. And the prior version of the statute and the regs authorized the consideration of assets, but provided no guidance on what assets were not appropriate to consider. So the statute provides quite a bit more detail on that. And you can see on the slide, it sort of importantly identifies what assets cannot be considered in a charity care analysis. So $5,000 of cash, equity in a primary residence, most retirement plans, most cars, prepaid burial contracts or plots, life insurance policies. And then it built in a number of important consumer protections in what hospitals, in regulating hospitals' conduct in requesting information around assets, because I'm sure a lot of people in the audience can appreciate this, the harder you make the charity care application process, the more likely consumers are going to be deterred from seeking charity care in the first place or not be able to complete the application. So the new law requires hospitals to not impose asset consideration procedures that place an unreasonable burden on patients. They have to limit documentation requests to that which is reasonably necessary and readily available. If consumers don't have documentation to demonstrate their assets, hospitals need to accept a written statement from them. And really importantly, information gained about assets through a charity care analysis cannot be used for later collection activities against the consumer. The bill went into effect in July of this year. And since then, the Attorney General's office has been doing a lot of outreach around the amendment, but also just around the availability of charity care generally. The Attorney General has done a number of teletown halls around charity care that I've participated in, and we expect the outreach to ramp up in the new year. So yeah, thank you for your attention. And my contact information is here, and I'm always happy to hear from people and engage around charity care issues.
Thank you, Audrey. I just have a quick question or two about the litigation. Is there anything that you can see happening in terms of its effect, or what you think might be the effect of the litigation?
Yeah, I mean,
hospitals in Washington state.
I hope it means we don't have to file any more lawsuits in the future about charity care. I mean, we weren't thrilled that we had to file this one after, all the work in 2017 and 2018. So the goal is to really get these particular practices done in Washington. I mean, obviously the objective too is to get restitution for the consumers, the specific consumers impacted by these practices as well. Providence is just such a big health system in Washington, where hopefully this is the last one that we have to file.
And you mentioned the town halls and outreach ramping up in the next year. Are there any particular issues involved in public education? I mean, for example, language access, or how you're reaching diverse communities with this message?
Yeah. So I was just in a meeting about the outreach that's going to be happening next year. So there's going to be a great emphasis put on working with Spanish language media, I think, and a number of other language medias, connecting with like local media markets, not just doing big media. And I mean, what's been troubling about the outreach I've been a part of and the litigation over the course, of the last 7 years is the real basic issue is that consumers still don't know about the availability of charity care. It's as simple as that, So the objective of the outreach is to keep it pretty simple and make sure it's really focused on availability. I get the same questions at every town hall, of like, and that just demonstrate like we have still not really permeated, consumers' awareness as well as we'd like to.
We do have a question from an attendee about what information is available on compliance with the provisions on the language access notifications that were added to the charity care law from 2017 legislation.
Yeah. So in terms of like whether like what has been collected in terms of observing hospitals' compliance.
Yes.
So yeah, good question. So, and it sort of gets into the differentiation between the Department of Health and the AG's office. So in terms of the, the confidential investigatory work I do and the litigation, I've observed compliance with that amendment, but I don't do kind of like routine. I only kind of get involved when there's concerns have already been raised, so I don't do routine audits. The Department of Health handles a bit more of that. So not to kick the can, but from what I've observed compliance.
Can you talk a little bit about how the DOH and the AG's office works together on the issue of charity care?
Yeah,
as you alluded to, yeah.
Yeah, I can give my best stab at it. I can't talk about all of it, but in terms of kind of the different statutory spheres, so the Department of Health directly enforces the State Consumer Protection Act. It does a lot of work around hospitals' written charity care policies that get submitted to DOH for review and comment. DOH then makes them available on their website, and DOH handles a lot of the kind of like daily oversight of hospitals' charity care programs. They act in an ombudsman role. And then the AG's office, enforces the State Consumer Protection Act. So does these kind of confidential investigations, brings lawsuits related to hospitals' charity care practices, and isn't kind of like the daily regulator in the charity care space.
We have another question that involves whether there is going to be any effort to exclude the consideration of assets that cannot be attached in collection. So, for example, retirement accounts.
I
consideration for charity care eligibility?
Yeah, it's a good question. And I know there's been discussions at least around changes to the language in the statute about retirement accounts in this next legislative session. I am a little out of the loop on like the day-to-day legislative work, but I know there is discussion in that area.
Great. Well, if it's okay, can we bring Jane back and have some questions for both of you? How do you see your agency's progress as contributing to the state's efforts to, towards ending medical debt? I mean, what work do you see in both of your capacities as really still needing to happen? I mean, we are in a good place, but where do you see us really needing to be?
So there's no question that what we need to do is not spend so much money on healthcare. Because consumer debt under even if I remember the deductibles for the silver QHPs that are sold on the exchange for folks who have income above 250% of the poverty level, you're looking at $2,000 to $3,000 deductibles. And when carriers file their rates with us for individual and small group health plans, we have a whole set of actuaries that are scrubbing those rates to make sure that they're justified. And what drives premiums are price and utilization. And when price goes up, then premiums go up. So all the work that the Healthcare Cost Transparency Board is doing, OIC has a seat on that board. I'm fortunate enough with Joan to have a seat on Universal Healthcare Commission. And so we took care of one piece of the puzzle with balance billing. The AG's office is doing great work trying to figure out after the fact how people don't have to file for medical bankruptcy. But that means we still have to work on the fact that the underlying costs are so high.
Are there any thoughts?
I mean, I adopt everything Jane said. As someone that looks a little bit more in a narrow view at like the consumer experience and reviews a lot of consumer complaints, I mean, just the sheer amount of confusion that consumers have with medical bills is, and it kind of ties in with charity care, still not even if there's a disclosure on the bill, still not really understanding the rights they have. And in these town halls, I've just been trying to emphasize, like, for consumers to feel empowered to call. I mean, especially with hospitals, they have financial counselors on staff that are supposed to be assisting consumers, and anything we can do to empower consumers to be comfortable asking questions, asking for help,
And my advice that I always give on anything that has to do with healthcare is if you don't get the answer you want out of the first person you talk to, just say you want to talk to their supervisor. And then you just keep going up the food chain.
Very good advice.
The squeaky wheel gets the grease in the healthcare system.
So looking forward, Jane, you had mentioned some degree of enforcement relative to could you talk a little bit? I mean, you said that there weren't very many complaints, but I'm just curious about what enforcement does look like for the BBPA.
So if we find it, and this is the way it works for any potential violation by a carrier of state law, if we find a potential violation, then we will go through a series of sort of information requests back and forth with the carrier. And when we are at a point where if the carrier does not agree with us that their practice violates the law and they need to modify their practice, then we can send out cease and desist orders. We can send out a draft consent decree or a consent order and get a response. And if we do take enforcement action, carriers have the opportunity to appeal it through the administrative process here at OIC. We don't have, with the staff that we have, we investigate as much as we can, but there's a lot of health insurance, a lot that goes on. But that's how we approach it generally. And those consumer complaints are really important, because if we start seeing a trend on consumer complaints anywhere, that means it's something we need to pay attention to.
Thank you. So Audrey, for the Attorney General's Office and Charity Care enforcement, I think you do have an area on the website where people can submit complaints. Can you walk us through what happens with those?
Yeah. So we have, and I can drop the link in the chat if that's helpful. So we have a whole team of folks that field those complaints and consumers file complaints. They are available to all of the enforcement folks who review them regularly to do what Jane is talking about, to look for trends. So they serve that function, but we also act as like a neutral third party. So those complaints then get forwarded on to the businesses, asking for a response. And so we're able to return quite a bit of money to consumers just through that informal mediation role as well. So they serve kind of a dual function there. And I'll drop the link in the chat.
That would be great. So given where we are in the nation right now, what do you think other states can learn from Washington State? I mean, if they wanted to make change in both of these areas, are there lessons that we've learned here that are worth passing along? What would those be? Jane?
Okay. So one issue that we've been talking to a lot of other states about is the opportunity to bring behavioral health crisis services into emergency services that are protected from balance billing. And I will say it is a significant challenge to implement that provision, because our behavioral health crisis system that's out there when you call 988 or, it's an insurance blind system. And the first thing that those folks are thinking about is helping a person who's in crisis and not what their insurance is. So it's really a challenge to implement, but we have a whole effort going on to try to figure out how we can get the information exchange back and forth so people can get coverage for those services. But we feel really, essentially it's EMTALA for behavioral health crisis services. That's sort of how we think about it. And in terms of the states, we share information all the time. I will say it was really heartening to see how much the federal agencies, when they were implementing the No Surprises Act, reached out to states that had already implemented their own balance billing statutes to learn from states' experience as they were developing the federal system. So that was heartening to see.
Audrey, what do you think about for charity care?
Yeah, and I've spent a lot of time on the phone with folks in AG's offices in other states, especially recently because Providence has such a national presence, and I can certainly say that these practices are not just occurring in Washington, right? Like these are practices that occur nationally. And so it can be challenging, right, to just only have jurisdiction in Washington. And there are practices that are good practices to challenge through Consumer Protection Act statutes. They lend themselves really naturally to that kind of unfair and deceptive framing. And I know that there's also, a lot of thought around, because most hospitals are nonprofits, right? So what their obligations are to the community as charitable institutions and as nonprofit institutions. And hospitals just play such a significant role in the healthcare system and have these really unique legal obligations to their patients that are different, from individual physician groups, legal obligations. And so just holding, being committed to holding these institutions accountable is important.
Is there an opportunity to pursue a hospital's nonprofit tax status based on the delivery of charity care?
It's probably I probably can't quite get into like the legal
That's a hard question to answer.
But it's something I encourage people to think about.
And so looking forward, both of you, what do you see as what is next on your agenda in here? Jane?
With respect to balanced billing, or yeah, it's figuring out how we can effectively ensure protections for behavioral health crisis services. That's, I think, the number one on that one. And then continuing basically to, I will say, working with the legislature on this issue, it has been fully bipartisan. So it's really nice to work on an issue that's a four corners issue where everybody's in agreement on the solution. I think the legislature would prefer not to see another balanced billing legislation. We actually
and you probably prefer not to have to do it again.
Right.
I mean, after everything that you...
Right. Emily would as well prefer that we not do it again. But we actually just issued proposed rules on our website. We just published proposed rules for implementation of that legislation as well.
So Audrey, you mentioned education outreach. Certainly the litigation is continuing. Is there anything else that you can think of that's on the horizon for the Attorney General's Office for Charity Care?
I think that's it. I mean, those are our three tools, but with a greater emphasis on the education and outreach than before, just with the understanding that litigation is great to return money to consumers. But, you know, unless we're reaching consumers through methods that are appropriate, we're still not really going to get where we want to be.
Great. Well, I thank you both so much for taking the time to talk to us today. Next, we will hear about developments in public charge litigation from Nicholas Espiritu, supervising attorney at the National Immigration Law Center. NILC is a national leader with deep expertise in immigration law and policy. Lawyers and advocates across the country rely on NILC as a key resource, and they've been steadfast advocates for immigrants. They are co-founders of the Protecting Immigrant Families Coalition that advocates for changes in public charge policy. Thanks for joining us today, Nicholas.
Thank you for having me.
Absolutely. Let me just pull up your slides.
Great. Thank you for that introduction, and we're really happy to be here. Just a little bit about NILC. Our mission is to defend and advance the rights and opportunities of low-income immigrants and their families. We don't practice immigration law and immigration court, but rather we work at the intersection of policy analysis, impact litigation, and communications, as well as in the substantive areas such as the intersection of immigration law, and areas such as benefits in healthcare. One of the goals of NILC is to make healthcare universal and available to all, regardless of immigration status. And I also want to thank Northwest Health Law Advocates for being a partner in our work in the Protecting Immigrant Families campaign. Next slide, please. So one of the things we really hope to cover today is a quick description of what the public charge statute is, how it's traditionally been implemented, what the effort was to expand it under the Trump administration, what is the state of the litigation related to the Trump public charge rule, and where are we now with relation to the public charge rule that has been promulgated by the Biden administration. Next slide, please. So it's worth remembering with regards to the public charge rule that much like other areas of immigration law, it is deeply rooted in a racist past that sought to make immigration from non-white countries extremely restricted. And it was part of a series of legislation passed in the late 1880s or the mid 1880s. That included the Chinese Exclusion Act and other overtly racist laws. And it has been on the books, although modified up until this time, and it's still part of immigration law, whereas many other parts of immigration law, including the Chinese Exclusion Act and others, have been removed from the immigration codes. Next slide, please. So the public charge statute provides a few things, but for the purposes of this presentation, we're going to cover the public charge ground of inadmissibility, which makes inadmissible persons who are likely to become primarily dependent on the government for subsistence. It uses what's called a totality of circumstances test, which was a later addition to the statutory regime, but is based on the earlier case decisions that look by statute at age, health, income and employment, education and skills, family situation, and whether or not the intending immigrant has an affidavit of support from a U.S. citizen or legal permanent residence. The statute can also consider cash assistance for income maintenance or institutionalization for long-term care at government expenses as benefits that that can deem an individual public charge. There's a slide problem. So what this can do is that if an individual is deemed to be a public charge, it can result in the denial of admission to the United States, prevent the adjustment to lawful permanent residence, or prevent the re-entry of an immigrant if they've been outside of the country for a certain amount of time. There are certain categories of immigrants who are not subject to the public charge law, including asylees and survivors of domestic violence and several other groups. One of the reasons this is important to remember is that many of the benefits which would have been considered part of the public charge determination are not available to many non-citizens, but for these groups, oftentimes they have greater access to public benefits, including healthcare benefits. And so that for many of the non-citizens who can access these public benefits, they're also not subject to the public charge statute. Next slide, please. So that's the general statutory regime, but as we saw, there's the totality of the circumstances test. There's a lack of clarity in the statute about which public benefits are included. But historically, public charge had been very limited and had really only focused on either cash assistance or long-term institutionalization, things that were equivalent to what the almshouses would have been in the 1880s and 1890s. And so this confusion about the scope of public charge was increased after the 1996 changes to federal immigration and public benefits law through statutes such as IRA and PERORA. And so after those 1996 changes, advocates worked with INS, which is now no longer existed, but is part of DHS, worked with INS to promulgate guidance that made it clear that the longstanding definition, which was really focused on primary dependence, what continued to be the guiding principle behind the public charge statute, and that they would only consider receipt of cash assistance for income maintenance or other long-term institutionalization. Oh, next slide, please, but I guess it's not up.
Please stand by, a little technical difficulty.
No worries. Can we go? Yeah. Can we go one slide back, please? Perfect. Thank you so much. So this had been the longstanding interpretation and implementation of the public charge rule, but with the Trump administration, with Trump being elected to the presidency, one of the early leaked memos from that administration indicated an intent to radically expand the public charge rule, and when this was leaked, NILC, along with other organizations, began to put together the Protecting Immigrant Families campaign as a way to fight back against both this and other federal changes that would have really limited access to healthcare. And it was in 2018 that DHS, the agency that replaced INS, published proposed regulations that would have that proposed radically expanding the public charge rule, including the number of public benefits that would have been taken to count towards the public charge determination. It also redefined the totality of circumstances tests in ways that really would have had a disproportionate impact on immigrants of color. And so this would have had essentially two outcomes that we saw. The first would be we feared, and the evidence showed, that this expansion would have a chilling effect on access to public benefits and healthcare, even beyond individuals that would be subject to the public charge rule, out of fear that at some point that accessing benefits that they would have been eligible for would have been used to make negative determinations when they sought to change their immigration status. And so we were concerned in both the health and other outcomes on immigrant and other communities. The second thing it would have done, and this is really related to the totality of circumstances test, is it really would have served the goal articulated by some members of the Trump administration to limit non-white immigration to this country. Next slide, please. So NILC, along with a number of other organizations, looked to prepare litigation challenging the new Trump public charge rule. And over 10 lawsuits were brought in various courts throughout the country. And 5 of these courts issued preliminary injunctions blocking the rule. I should say that many of these lawsuits were in the same location. For example, NILC's lawsuit brought in California was in the same court as lawsuits brought by the state of California and the city and county of San Francisco and as well as Santa Clara County. Another entity that had brought a lawsuit was the state of Washington, who was a great partner in fighting back against the public charge rule. So while there was overwhelming success at the district court level in getting the rule initially blocked, the Trump administration quickly appealed these rulings, including a very rapid appeal to SCOTUS, asking them to stay all the preliminary injunctions until the appellate procedure could be fully litigated. However, during this time as well, we entered the COVID pandemic, and the fears about the chilling effects motivated additional courts to rethink the preliminary injunctions. And despite the concerns about the public health outcomes, the Trump administration continued to appeal these rulings and stay the injunctions that would have blocked the Trump public charge rule. As these appeals kept moving through the courts, and there was additional success at the appellate court level, the U.S. government sought certiorari to the Supreme Court, and they accepted review of these cases. However, simultaneously, there was at the district court a final adjudication of the public charge rule, finding that it violated the APA and issuing an order vacating the rule. However, that ruling was stayed as a result of the other appellate litigation. Shortly after, the Biden administration took office, and while the cert petition was pending at the Supreme Court, the Biden administration issued an announcement saying it was going to rethink it was going to take another look at the rules and issue a new rule, and eventually withdrew the cert petition, allowing the final order vacating the Trump rule to go into effect. However, the litigation there still continues. Texas and Arizona have sought to intervene. An initial effort was rebuffed, but they still seek to intervene to defend the rule in the Seventh Circuit. That new cert petition, attempting to restart a defense of the Trump administration's public charge rule, is still pending, and briefing is ongoing there. So maybe to wrap this up, and we can talk a little bit more about what the state of the public charge rule is that currently the Biden administration has issued a final rule, essentially returning the public charge policy to the 1999 field guidance. There also have been additional changes to the public charge regulation that help clarify the type of benefits that will be considered, as well as clarifying the ways in which the use of a affidavit of support will be used. We have additional materials here in this presentation that run through what the factors are and how that's going to be determined, and what the clarifications and improvements under the new Biden rule are. And maybe finally, it would be, it's important to remember that while the Biden administration has issued a new rule, there have been comments by states such as Arizona and Louisiana, as well as by anti-immigrant groups, saying that they intend to sue to block any new Biden public charge rule from going into effect. So we don't expect the litigation to be over, or the fight to ensure that the public charge rule remains humane and attentive to good public policy. But we'll continue to be here to provide updates and information, and ensure that immigrant communities are defended and that healthcare remains as available as possible.
Thank you, Nico, for bringing us up to date on the developments in this very fraught area of public charge. And thanks to you and Nilk for doing such amazing work to promote the benefits of the regulations and to comment and to pull together a coalition of folks. It's been a wonderful opportunity to turn things around, hopefully for good. I appreciate your presentation. We don't have any questions here, so I think we'll move to the end of this CLE. And I'd like to thank all of our faculty for sharing your wisdom for this full day of exploration of health law policy and how the courts are shaping our future. I'd like to sincerely thank our staff, Leslie Bennett for coordinating the many aspects of this program, Hathaway Yates for managing all of the technical aspects of coordinating the seminar, Michelle Johnson, our great development consultant, for her support, and the entire NOLA staff who contributed in many ways to this event. And again, thanks to our wonderful sponsors for making this event possible. Everyone who attended will be getting a course evaluation. Please complete it. CLE participants, remember to sign in. Last reminder to sign in on the attendance form and contact us if you need help. The recording of this event will be available soon. And please consider supporting NOLA's work. We engage in a range of advocacy on healthcare justice, and we greatly appreciate any donations, no matter how small. Visit our website, nohla.org, to find out more. Thanks again, everyone, for joining us today. We hope you come away with knowledge that is helpful and actionable.